They gave me the gavel back. 8:31, and I'm going to call this meeting to order. Commissioner Butler will do the invocation. Again, anyone who wants to participate is welcome to, but it's strictly voluntary. Commissioner Butler, and also Commissioner Butler, would you mind including Senator Creighton on your prayer, if you don't mind? That would be
absolutely
very great.
Absolutely. Thank you for mentioning that. Dear Lord, we come to you today with humble hearts, and we beg you and we lean upon you and ask for wisdom as these cases come before us, Lord. We lean upon you and say, give us the grace that we need to deal with these citizens of Texas that come before us with the mercy and kindness that we would want if we were in their shoes, Lord. Help us make good decisions for this great state. And Lord, we ask a special blessing on Senator Creighton. We ask for his healing. We ask that you guide the doctors and nurses and professionals that are taking care of him. We beg you, Lord, to please bring him back to good shape. Watch over him. Watch over his family as they suffer along with him. We ask this in your holy name. Amen.
Thank you, Commissioner Butler. All right, Tamala, would you please call roll?
Chairman Rick Figueroa.
Here.
Vice Chairman Tom Butler.
Here.
Dr. Ray Callis.
Present.
Commissioner Helen Collier.
Here.
Commissioner Nora Castaneda.
Here.
Commissioner Joel Garza. Dr. Gary Weston.
Here.
You have a quorum.
Thank you, Tamala. I appreciate it.
Mr. Chairman,
Yes, sir.
I would like to make a motion if you're okay with that, sir.
Yes, sir.
I would like to make a motion that the commissioners excuse Chairman Garza for his absence, if that's the will of the commission.
Excellent. Without any objection,
No objections. I second.
motion carries. I want to take a personal privilege here. We have to recognize a commissioner. I was told a week ago, I guess it was a week ago, a couple of weeks ago, we were discussing with Francis, and Commissioner Collier was being recognized. She's president of Permit Us Now, and there's National Women in Construction Week, and I have her, I don't know if you can see this, but look at that young lady working hard in the downtown city area, and I wanted to recognize that. So if you guys just, yes, I'll give a little applause to one of our own getting recognized. So congratulations, Mr. Collier. I don't know how you got to get that paper to stay on that hood without a wind downtown. I don't know. Thanks a little Photoshop on that, I'm not sure, but
You have to pay me for that.
that must be some kind of construction permit to get that to stay where it is. I'm not sure. But congratulations, Commissioner Collier. We're very proud of you. Thank you for doing that, and thank you. Okay, we're going to go on to item D on the agenda, which is public comment. Any person wishing to address the commission must submit an email by following public comment instructions following the last page of this agenda. We're accepting public comments in writing and video teleconferencing for those who submit a request in advance to speak to the commission. We received, I think it is 3 written comments. If I understand, is that correct, Pamela?
We received a total of 5 public comments, and 2 of them requested to speak, and only 1 is present for the call this morning.
Okay, so 5 total, 3 are written, 2 will speak, 1 is present. I think you guys got a copy of the written ones. We'll bring the first commentary in the meeting. That person will have 3 minutes to speak. There'll be a brief pause while we bring the next commentary on in the meeting room. Again, commissioners can remind you a couple things. One is mute your cell phones if you don't mind. Remember, you're on camera. Keep your camera on at time. I got about 20 people that I'm looking at. So if you have a comment, I don't see you, just wave your hand. And I guess Commissioner Weston can throw something at me, but because he's here in the room with me, which is hopefully we'll get the next set round. We'll be able to get to see each other in face to face. So Tamala, are we ready to go?
Yes, sir.
Okay.
We have Mr. Andrew Alexander, who's being moved into the meeting.
Mr. Alexander, can you hear me? There you go. Mr. Alexander, can you hear me?
Yes.
Perfect. Thank you. Mr. Alexander, thank you for coming and giving us your public comment. I want to thank you for being here. Please state your name and who you represent. You'll have 3 minutes. Please understand the commissioner are not allowed to ask questions or engage in discussion with you about anything that is not specifically on our agenda. Please also understand the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be the decision maker in the case. You understand, Mr. Alexander?
I do.
Perfect. Okay, your 3 minutes begins. Go ahead.
Hello, commissioners. My name is Andrew Alexander. I run a massage school here in Texas. The department recently implemented a process to bypass school transcript release, and I wanted to talk a little bit about the consequences of these actions. So if you're unfamiliar, TAC 11764 has a transcript release process which requires students to meet their financial obligations with schools prior to the release of a transcript. What this really does is encourage massage schools to admit basically any student interested in massage, regardless of a student's background or their present economic conditions. It offers just enough protections to the schools that they don't have to worry about financial problems. To give you an example, at my school, I don't run credit checks. I don't worry if students have a bad month and miss a payment. I don't charge interest. I don't even have a debt collector. My program is open to anyone. On April 23rd, all of that changed. As part of internal process optimization, TDLR is now issuing licenses prior to transcripts being released by the school. This bypasses all the protections for schools. I've included attachments 1 and 2 to kind of break down how this happened. Now, the education group did issue a statement confirming that this was the case and that schools are now expected to fend for themselves. I've included that as attachment 3 if you've not seen it. As businesses, we do have to adapt or die to new regulation. It's just a part of operating. Can I continue operating as before and still remain in business? No, I can't. Protected. Schools are going to have to begin screening their applicants to ensure that there is a history of financial responsibility and that we're likely to be paid. That means that the most financially insecure demographics will be excluded. To fully understand how this would impact me, I evaluated my current student base. Because of my demographics, I'm less impacted than most, so I can offer some of the most generous terms. Still, the results were concerning. The list of students that have been negatively impacted by the department's changes is about 85% Black, African American, and 15% Hispanic. No Asians or whites were affected. Now, for full disclosure, not every massage school is going to feel the same way about this. Changes like this have a habit of hurting some while helping others. I want to make sure you understand who you are hurting and who you are helping. For instance, my school runs very small, fast, intense classes. They have low margins and are designed to get people trained, debt-free, and working as fast as possible. I included my test results for the last quarter. I score about 10 points higher than the state average on my tests. And that includes counting students that aren't even fluent in the testing languages and without taking the department's COVID incentive. This program is ideal for people seeking rapid ascension to economic stability. It's also the kind of school that you want to send your kids to before they go to college so they can make real money during that time. Schools, kind of like mine, are going to be unhappy with these changes. Then you have your Title IV schools. These are schools that take 2 years to complete, charge 3 to 4 times what other schools do, and they have much higher dropout rates. When you leave these schools, you will have a very good education, but you'll end up with the same license as everyone else and 5 to 10 years of student debt. These are schools that are going to be happy with your changes because they're unaffected by transcript release and they're federally protected. Then here's your transcript farms. I'm sure you've all seen the WeChat videos of 50 students in a chat room with 1 teacher teaching and 2 teachers in the background to maintain legal compliance. These are schools that will never run out of room. They will complain about this situation, but in the end, they will be happy to pick up the extra students that I can no longer afford to teach. Now, again, your education director has made it clear that this situation is none of the department's business. I'm not here to challenge that. It just seems like a very poor trade-off. It appears that the department is taking these actions to save about 2 minutes of time for every license that's issued. I've talked in the past about the slowness of licensing. I think it's a good thing, but I think that with some minor changes, you can accomplish this here without hurting some of the most socioeconomically disadvantaged students.
Mr. Alexander, you've got about another 10 seconds to wrap up. Just want to let you know
Okay.
that.
my request is that the commissioners review the situation and decide if it's a reasonable, if there's a reasonable fix to this situation. If I'm, and that's basically what I'm looking for. I am available for questions. You have my number and my email address.
Mr. Alexander, a couple of things. One, I can appreciate your due diligence. That is always good information, get feedback like that. We can. I know the staff has some points that they want to make with you. They're going to follow up with you. So I appreciate your time and the effort that you're putting into this vocation and this industry. So thank you again, Mr. Alexander.
Thank you.
Okay, I think that's it for public comment. I think Mr. Francis just informed me. So we need to move to item E, which is a motion to accept digital signatures or electronic signatures.
Make a motion to accept digital and electronic signatures.
Second.
All in favor, say aye.
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 Opposed? Okay, so motion carries. We're gonna need the minutes. You've been given a copy of the minutes.
So moved, Chairman.
There's a
Second.
second.
Commissioner Collier.
All say
Aye.
Aye.
Opposed? Motion carries. Excellent. On to executive session. We're gonna now go to the executive session, consult with our attorney under section 551.071 subset 1 and 551.071 section 2 government code. The time is 8:43. After the executive session, we'll take a break and come back, and we're going to give ourselves till 9 o'clock to pick up with any action in the executive session. I don't think we have much. In 15 minutes, I was informed to be plenty. Is that right, Della? Okay, so we're going to go into executive session. Commissioners, make sure you log out of this meeting and log into the executive session meeting. Is 9:10. Call us back into meeting back into order. We're back from open session, and there's no actions needed on the executive session items. So we're going to move on to item H, which is the contested cases, commissioners. If anyone has indicated that they need to appear today for a case, staff has provided them with information on how to connect to this meeting, and we'll bring them into the meeting when they announce the case. Right now, I think we're going to go with number 1 on the case, which is Mr. Reyes. I think, is that right? Correct?
Yes, sir.
Okay. Yes, sir.
And just for the record, we're on item number I for contested cases.
Yeah.
Thank you.
Yeah. Okay. Oh, as always, thank you. Appreciate that. Item I, item 1 of number I is Mr. Reyes. Are you there?
Yes, sir, I am.
I'm trying to find you. Where are you? How come I can't see you? Oh, there you are. Thank you, Mr. Reyes. All right. All right. Go ahead.
Thank you, sir. Good morning, Mr. Chairman and Commissioners. I am Robert Reyes, an Enforcement Division Prosecutor. Jaime Aribia originally represented the department in this case before SOA on November 3rd, 2020. The administrative law judge, in her amended proposal for decision dated February 10th, 2021, recommended respondent Kyle Pentecost be assessed an administrative penalty of $3,000 for engaging in air conditioning and refrigeration contracting without holding an ACR contractor's license. The department staff requests that you accept the amended PFD as written. Prior to the most recent notice of alleged violation sent to respondent, which initiated this case, a January 30th, 2013 commission order was signed against respondent for offering to perform ACR contracting without a license. That order included a $3,000 administrative penalty. The most recent notice of alleged violation included allegations of both unlicensed electrical and unlicensed ACR contracting. However, staff dropped the allegation regarding unlicensed electrical contracting in its exceptions filing, as the notice of administrative hearing sent to respondent inadvertently omitted that allegation. During the November 3rd, 2020 hearing, the parties stipulated on the record that respondent was not, at that time or any other time in the past, licensed as an electrical contractor or ACR contractor. Additionally, the exhibits admitted also included a cease and desist order signed by the executive director February 5th, 2020, which explicitly directed respondent from, quote, acting as, impersonating, performing, or offering to perform work as an air conditioning and refrigeration contractor, unquote. Despite the previous commission order and the current cease and desist order, which respondent admitted he received, respondent continued to offer contracting work as an unlicensed ACR contractor through his website. After her analysis of ACR contracting, the ALJ concluded from July 31st, 2018 through December 23rd, 2019, respondent Pentecost engaged in ACR contracting without holding an ACR contractor license. The staff requests that you adopt the amended PFT as written and assess an administrative penalty of $3,000 against respondent. Respondent continues to violate ACR program laws and rules. He was previously penalized by this commission for this exact type of violation, and there were no efforts made by respondent to correct the violation, even though staff was in communication with him in an attempt to get him into compliance. I'm available at this time to answer any questions you may have.
Thank you, Mr. Reyes. Any questions from commissioners?
Mr. Chairman, this is Commissioner Collier.
Yes, Commissioner Collier.
Thank you, Robert, Mr. Reyes, I really appreciate the transparency in the document here for some items that were missed, and so I really appreciate that. For the prior penalties, were those paid in full?
Let me check for you, Commissioner. Give me 1 second. I don't believe they were, but I will see if they have. given me any information on that.
Commissioner Collier, great question, because I was concerned about the same thing, to where, you
Mhm.
know, all bark, no bite, and I want to see what the respondent has done.
Mm-hmm.
I'm looking through the ACR file from 2013. That might be the wrong case. Give me one more second, Commissioner, if I may.
Okay. And was there, I guess for January 23rd, 2020, was there a penalty there? What was the amount? And if it's same question. Mhm.
Yes, the 2013 order was for $3,000 for both ACR and ELC contracting through a website. I think it's important to note that it's the same website that was itemized in this case. I do see a commission order paid 9/11/2014 for a commission order. Let me check to make sure it's the same one that I have itemized in the. I will say this, Commissioner, we do have a penalty paid that we received September 11th, 2014. But there are so many cases with Mr. Pentecost, I can't tell you in good faith that he paid this exact penalty, but we have received a penalty payment September 11th, 2014.
Mr. Reyes, this is Commissioner Callis. I have a question for you, Mr. Chairman, if it's okay.
Yes, sir.
My question is that can you tell the commission how many times and how many variances does this gentleman have? Because that will lead to my second part of my question.
I'm unclear on the term variance, sir. Like, what do you mean by
What I'm
that?
saying is that how many different times has he been reported? You said he's had multiple, and I would like to know what multiple means.
Yeah, how many
Yes,
cases,
sir.
Robert?
Yes, sir. Give me 1 second, and I can pull that up and give you an exact number.
Mr. Chairman, this is Brian Francis. Robert, you're doing a good job for picking up this case from.
Yes, sir. Thank you.
Continue to pepper him with as many questions as you can create.
It looks like I have 7 cases that Mr. Pentecost has in his under his name card that are unique case numbers. So they go back all the way to cases that start with ELC and ACR 2012. So that might be back till 2011 because of the way we date our cases by fiscal year, not by calendar year.
Well,
So
thank you, Mr. Reyes.
Yes, sir.
So what you're telling me is that since 2011, which has been 10 years, this website has been up and running, and it's been having multiple false accusations that he is a certified ACR and an electrician. And the problem that I have is that if we've been dealing with this gentleman, with all due respect, what is our next step if we continue to go down this path? And Charles, I'll yield to you, or Della. I'm just trying to see what our next step is and to see where we go from here.
If I may, Commissioners, I think that this is a case that we will take a look at, and maybe I believe a candidate to refer to the Attorney General's office for to step the enforcement actions up and to try and get an order for him to cease and desist, which will then lead to a potential penalties from the district courts if he continues to violate the commission's orders and the rules and statutes.
Thank you, Mr. Johnson, for explaining that, because I wanted to make it very clear that whenever we go through this TDLR process and we listen to a contested case, I wanted to make sure that, one, penalties and what we decide as a commission, we also can take it to a higher level if we continue to have cease and desist, where we still continue to get bombarded whenever we're trying to do the right thing for the state of Texas and every person in the state.
Yes, sir. And I can assure you that at the end of this meeting, there'll be discussions about making those referrals.
Thank you,
Yeah, this
Mr.
is
Chairman. I was going to say if there's other questions, I'll be quiet, but I would like to make a motion, sir.
Commissioner
If you can
Callis?
hold, Commissioner Callis,
Just-
this is a commission.
Just to give me a second. What I want to do is we'll go through that, but Commissioner Collier finished up, and then I got a quick question for everybody. Go ahead, Commissioner Collier.
Thank you, Chairman, Mr. Chairman. So, yeah, I mean, I definitely echo Dr. Callis, Commissioner Callis's comments. But as I look at the cease and desist letter that went out February 5th of last year, and you continue to operate in a vein, then right on, we need to take it to the next level. And again, it's about making sure that we're respecting and providing what's best for the citizens of Texas at this point.
Any other comments from any of the commissioners? All right. I agree. The chronicness of this case is something to be contended with. And as much as we want to expose grace to people that have had the problems, we need to make sure that our teeth are sharp and are capable of taking task when need to. So that was probably an item we need to take Mr. Francis to look at that on the chronic, because this probably will happen again. So we need to kind of see what other weapons we can put in that arsenal. All right, Dr. Callis, you had a motion.
Yes, Mr. Chairman. You and Commissioner Callier eloquently explained with Mr. Reyes the chronological problems. So I make a motion to accept the PFD. And also, Della, I don't think I can add it, but you've already answered it. I want to make it very clear that we will go to the OAG and discuss after this, but I want to make sure that's on record that we're going to continue to go that. But for my proposal or my recommendation, my motion is to accept the PAD and the penalty of $3,000.
Yes, sir, we will. The litigation team, my team in the office is the one that corresponds with the OAG. And they have their procedures, but we're a client of theirs, and so we will begin those discussions.
Thank
This
you.
is Commissioner Collier seconds the proposal for the PFD to be as a recommendation.
So we got a motion, and it's been second. All those in favor say
Aye.
Aye.
Great. Motion carries. Thank you. Thank you, Commissioner Collier. Thank you, Commissioner West. And so putting the point of this out. All right, we're going to go to item 2 on item I. So, Mr. Reed, where are you at?
Can you hear me?
I can hear you, but I can't see. Where are you? Oh, there you are, Mr. Reed. I got you. Okay. Mr. Reed, you have the floor.
Mr. Bruce was going to attend.
Okay, let me see if is Mr. Bruce in there?
Yes, sir. We're moving him now.
Okay. Mr. Bruce, can you hear me?
I can hear you.
Good to see your face, sir.
Good to see everybody.
All right. Let me read this to you because I know you heard it, but I want to make sure it's clear. We'll hear from the prosecutor first, and then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly. Say your name and who you represent. Each side will have 5 minutes to speak, up to 3 minutes for rebuttal if needed. Please understand the commission can only consider information that is in the record from when the case was heard at SOA, so you must limit your comments to those matters that were presented in the SOA hearing. Mr. Bruce, you got that right?
Yes, I do.
I'm sure you do. All right. Mr. Reed.
Mr. Bruce, can you hear me?
Yes, I can, Tony. Mr. Reed.
Thank you. Good day, Mr. Chairman and Commissioners. My name is Anthony Reed, and I'm a prosecutor in the Enforcement Division. These two cases were presented at SOA by Michael Shirk, who retired in December, and Jaime Aribia, who's no longer with the department. The ALJ found that BSF licensee J&B Hicks intentionally engaged in a flipping scheme involving deceit, dishonesty, and misrepresentation. Flipping is the use of deception to induce vehicle owners to sign documents authorizing the transfer of their wrecked vehicle from a regulated VSF to an unregulated body shop. The victim in the first case was Terry Bosley. The ALJ's recommendation that the commission revoke the VSF license of J&B Hicks and assess an administrative penalty of $5,000 is based solely on the Bosley case. The ALJ recommended no action be taken against the respondent in the second case. The department requests the commission adopt the PFD as written with one minor technical correction. The technical correction is in the findings of fact on page 28. The case number heading contains 2015 and should contain 2018. On March 5th, 2018, respondents VSF accepted Ms. Bosley's Kia for storage after the Kia sustained very heavy crash damage. The next day, Ms. Bosley and her husband went to the VSF. Ms. Bosley was approached by Ruben Montelongo, a salesman employed by Eastex Collision Body Repair Shop, or Eastex. He did not identify himself as an employee of Eastex, nor did he direct Ms. Bosley to a VSF employee. Ms. Bosley told Mr. Montelongo she wanted to release the Kia to her insurance company because the Kia was totaled. Mr. Montelongo persuaded the Bosleys to have the Kia transferred to Eastex, supposedly to give them more leverage with their insurance company. Otherwise, they might only get salvage value for the Kia and owe more than the settlement. The Kia was flipped to Eastex. The bill was $1,380.45 after one day. Had the Kia remained at the VSF, the bill would have been approximately $276. The ALJ's analysis found evidence demonstrated respondent used deception, dishonesty, and misrepresentation. Specifically, one, the VSF and Eastex share the same office space, which obscures the fact two businesses exist there. Eastex salesperson Mr. Montelongo greeted Ms. Bosley. She had no contact with any VSF employees. Two, the documents Ms. Bosley was told to sign were not fully completed. The ALJ said the very practice of having customers sign blank documents is deceptive and dishonest. Three, Mr. Montelongo misrepresented that Ms. Bosley's signature was for the purpose of starting the estimate process. Actually, one of the documents, the work order, granted a power of attorney and authorized repairs. Finally, the ALJ said the only party that benefited from the transfer was respondent. The ALJ found respondents' actions demonstrated a lack of honesty, trustworthiness, and integrity. The ALJ found it reasonable to conclude that respondent knew of and approved of non-VSF employees dishonestly conducting VSF business with VSF customers. Given the respondent's failure to recognize its own egregious deceptive practices, the ALJ found that revocation of respondent's VSF license was appropriate. The ALJ found respondent intentionally engaged in deceptive practices to induce Ms. Bosley to transfer the Kia. The maximum penalty of $5,000 is warranted because the respondent failed to even acknowledge a violation occurred and is unlikely to alter its behavior. The department requests the commission adopt the PFD as written with one technical correction in the finding of fact heading on page 28. I'll be happy to answer any questions.
Thank you, Mr. Reed. Any questions, commissioners? For Mr. Reed?
Yeah, and again, what's the, on the page 28, what's the reference that you're mentioning, Mr. Reed?
The heading separating the analysis for the different cases, there were two cases. The heading has 2015 instead of 2018. It's VSF 2015-5000-7719. It should be VSF 2018-000-7719. It's a typo.
And just for the record, I don't have any problem with that amendment.
Okay. Thank you, Mr. Bruce. Any other comments for Mr. Reed? Okay, Mr. Bruce, you're gonna have 5 minutes. Again, remember, contain it to the SOA hearing.
Understand.
You have the floor.
Okay. First, I'd like to remind the commission that TDOR does not regulate body shops or body shop employees, and that all the conduct complained about was by a body shop employee and not a VSF employee. Mr. Montrago did not hold any type of license from TDOR, nor is he required to hold a license. So that basically we do not believe that his conduct falls within the jurisdiction and authority of TDOR. I would point out in the Bosley case, which we're mainly focused on, the conduct complained about was not taken at the VSF, was not taken at the scene of the tow, which we have seen in many of these flipping cases. That Miss Bosley and her husband, accompanied by her husband, came in the day after her vehicle was towed to the VSF. Yes, she was met by Mr. Montrago, a body shop employee. At his desk, the evidence showed that it was clear that he worked for the body shop and that all the body shop rates and everything like that were posted directly behind him. Miss Bosley and her husband voluntarily sat down at his desk. Mr. Montrago went through the documents with them. They had time to read the documents, make pictures of the documents. And additionally, she was given and signed a form distributed by the Harris County Sheriff's Department that advised vehicle owners that they are not required to sign any documents to have their vehicle released to the body shop. That if they did have the vehicle released to the body shop, that they could incur substantial fees, including administrative, safekeeping fees, teardown fees, and a transfer fee. This is in 14-point type, and it's on Harris County Sheriff's Department letterhead. They were given that document and they signed it. That Miss Bosley had time enough to make pictures of everything she signed. She initialed every document she signed. Her husband signed with her. So we just do not believe that this was dishonest conduct. The fact that she didn't read the documents or bother to go through the documents is not Mr. Montrago's fault. They were in the office. I believe the testimony was for about 45 minutes. So they had plenty of time to make the decision. They were under no pressure to make the decision. They could have said, no, I don't want my car taken to the body shop. Mr. Montrago explained to them that he did believe, in his opinion, that they would get a better settlement from the insurance company if the car was at the body shop versus a VSF, where the insurance company could take it out at any point in time. This is not dishonest conduct. It's simple salesmanship. And we just not believe that that warranted a revocation of my client's storage lot license. This was not taken by a storage lot employee, and it was not under a pressure type situation. Both the vehicle owner and her husband were there. The documents that, she provided a copy of her driver's license to Mr. Montrago, who made a copy of it and had the documents notarized. There just was not any, this was not a, as we've seen in other cases, they're signing stuff on the side of the road. They're signing stuff on the hood of a tow truck. Their vehicle is towed into a VSF at late night, and they're signing documentation there. No, this was all the day afterwards under a normal, with her husband. Did Mr. Mock employ some sales tactics? Of course he did. But that, they wanted to get the car into their body shop. But those sales tactics are no different than when you go to a car dealership. And there was plenty of time for them to read the documents. She signed and notarized every document and was given warning by the Harris County Sheriff's Department, a form promulgated by the sheriff's department, explaining exactly what could happen if she signed these documents. And yet she signed the documents and made pictures of the documents on her phone. This just is not dishonest conduct. And we do not believe that revocation or fine was appropriate in this case. That's all I have.
Mr. Bruce, thank you so much. Any comments or questions, commissioners?
Mr. Chairman, Commissioner Collier, I have a question for either Mr. Reed or Mr. Bruce, since he just spoke. Where was the car towed to?
It went from the accident scene to a licensed vehicle storage facility. It did not go to the body shop.
Okay, thank you. So it went to the licensed vehicle storage facility. Thank you. So how did and who authorized, and was the VSF that's licensed aware of the tow of the car that went approximately 100 feet to the body shop?
She came in the next day, and she authorized that tow. She came into the body shop and then signed the documents that authorized the tow after sitting down with Mr. Morago for about a half an hour, and then authorized the tow, the release of the vehicle from the VSF to the body shop. And I just wanted to add it, there was never any intent to repair the vehicle. It was, as she admitted, it was explained to her that this was just so she could get a better settlement with the insurance company, not to actually do a full repair on the vehicle.
So was the VSF aware that the car was being moved 100 feet?
Yes, I mean, the documents were put in the VSF file to say, it's being transferred over. The VSF file was closed out before the vehicle was released, based on the documents that she had signed. With the work order, there's also a transfer order. And again, she signed that and took a picture of that document. And that's what the Harris County Sheriff's form or notice basically tells people, that if you have your vehicle transferred, and I can bring up the language if you'd like to see it, I have it, that you could incur all these fees. And it's in big 14-point type. The Sheriff's Department promulgated that form and required it of all Harris County VSFs to give to vehicle owners, so they know what could happen if they have their vehicle transferred. I don't know what more warning we can give than 14-point on sheriff's letterhead, telling them exactly what's going to happen and the risk of doing what they did.
Okay, Mr. Bruce. Commissioner Butler, do you have a question?
Mr. Bruce, it's always good to see you. You're one of the most formidable advocates when you appear before us, and it's good to just see you again.
Good to see you, sir.
If Mr. Chair, if you might, I'd like to make a motion.
Yeah, just stand by, because I do have a question.
Yes, sir.
For Mr. Reed, and I want to allow the commissioners, any of the commission, or Mr. Reed, did you want to respond to the comment?
I believe I have 3 minutes to respond to Mr. Bruce.
You go ahead, Mr. Reed.
First, the VSF was a participant in the dishonest conduct. Both the general manager of the VSF and body shop, Mr. Dieter, and Mr. Hicks, the owner, both testified that Mr. Montelongo's behavior was fine, but the ALJ found it misleading, dishonest. We don't believe that the body shop or VSF is entitled to lie about the effect of documents and then rely on the documents being signed. The documents were not complete when they were signed. And that was Mr. Montelongo saying he would fill the documents out later. The ALJ pointed out the only person that benefited from this was the respondent. That's who got $1,300 for what should have been less than $300 in the VSF. The ALJ looked at the evidence and clearly said it was dishonest misrepresentation. Thank you.
And
Okay.
to clarify, excuse me, Mr. Chairman, did the respondent JB Hicks, did he receive all of that 1,300 some change? Because I thought that went to the body shop, with the exception of maybe that whatever that storage fee might have been. I just want a clarification.
JB Hicks owns the body shop and owns the property that the body shop and the VSF are on. So, yes.
Okay. Any other questions?
Yeah, I have a question for Mr. Bruce. Mr. Bruce, did you nice to see you again, sir, like always.
Good to see you.
Did you represent J&B Hicks at the SOA hearing?
Yes, I did.
So this is just my question. It sounds like the ALJ had no problem, and it was very clear to the judge that there was deceptive practice going on. And to me, it's pretty clear, but I just want to say that you always give your clients one heck of an argument, and thank you for your explanation. But I'm just telling you, Mr. Bruce, I have a hard time believing that JB Hicks and them, since they own the property, they own the VSF, and they own the body shop, where I'm having a problem, if the papers were not filled out, that I was under the assumption they were, until Mr. Reed said that the papers weren't filled out, but they signed a document. In my profession, that's called, I can be reprimanded and revoke my license as a medical doctor by doing that. So I just wanted to say that I think that that's a big concern for me, that when things are not completely filled out and you get someone to sign, there's a lot of room for deceptive discussions that go on. And that's just my point, sir, with all due respect.
If I may respond, the document that was not filled out was the body shop estimate. It was not that the documents that were filled out in the sense that, you know, the name and the vehicle type and everything like that. And the documents as far as releasing the vehicle were filled out. Because that has the vehicle information has to be on there. But part of the document that was not filled out was the actual vehicle estimate. And because so that part was not filled out, and that's done after the estimate is done. So it cannot be filled out before the estimation is done. And there was some question whether this current estimation would have been done, since it was, everybody kind of agreed, hey, we're probably not going to fix this vehicle, but if you have it here at the body shop, it gives you a little more leverage with your insurance company. So I want to clarify what documents were not filled out, or what part of the documents were not filled out. All the information as far as, yes, the vehicle owner's name, vehicle type.
Yes, sir, I hear that, but here's my, I feel, and I want to ask you as an attorney, say that you fill this document out. Why would you get anyone to sign without an estimate being on this document before you sign it over from a VSF to a body shop?
Well, because the estimate can't be done until the vehicle is released to the body shop.
Well, then I think that we have to work on that, because that makes no sense. Why would I sign a document and knowing that the body shop just 100 feet away could charge me $12,000 because I don't have an estimate to even look at?
And actually, the testimony was that the estimation fees and everything like that were posted behind Mr. Monterago at his desk, okay, with a big sign. So there is notice given, and that was a testimony. There was, you know, and that, I will say this, and while we may not like it, but that's pretty much standard procedure in any body, repair shop. Is you bring your car in, you sign the authorization, and then they'll say, okay, we'll give you an estimate after we look at the car.
Thanks,
and that's the part of the document that was not signed. I mean, not filled.
Thank you. I appreciate it, Mr. Bruce.
Forgive me, Mr. Chairman, just one last question for Mr. Reed. Mr. Reed, you noticed, and this is Commissioner Collier, that JB Hicks owns the body shop as well? Because I know that I had read, I'm sitting on page 5, because I remember circling it, that he owns the property. So, but you're saying he owns the body shop too?
Yes,
And
Commissioner.
I'll answer. Yes, he does. I'm not good. Yes, he owns.
okay, thank you so much. Yeah,
Yes, he does.
I mean,
Yes.
I agree. I mean, there's a closeness and there's an environment of knowingness and for misleading. So thank you. I appreciate that. Thank you, Mr. Bruce.
I think they share office space as well. I think that was also stated, Commissioner. So,
Yes, thank you.
The office space, they share the same office space, the same waiting room, everything. And the testimony by Mr. Montelongo about the signs on the wall behind him was conclusory, and there were no photographs to back that up. And as the ALJ found, Mr. Montelongo's testimony was suspect.
okay.
If I'm, hang on.
Go ahead quickly, Mr. Bruce.
Again, I think there were the Harris County has taken steps to protect vehicle owners. And again, I want to go back to this form that it's a one-page form that they're required to hand out. It basically tells the vehicle owner, be careful what you're signing. And you're going to, if you release your vehicle. So, I mean, it's not like, the vehicle owner, Ms. Bosley, admitted she saw that form. It's in big type saying, if you release your vehicle, here, you can incur all these fees.
Okay. Thank you.
Mr. Bruce admitted that they were there 45 minutes. Mr. Montelongo was telling horror stories of insurance companies not paying the correct amount. And
okay, we just want to keep the
misrepresented what the forms were for.
okay. Let me stop it there. Just a quick clarification, and this is I don't want to go down this rabbit trail too much, but the context of the notary, I know it's a different set, but that notary's book was stolen. Is that accurate? What's the context of that?
If I might, they had a break-in at the shop after this happened, and yes, there was the fact that that's one of the things that was taken. Well, a bag was taken, and her notary book was in there.
Okay, and Ms. Silva does not recall notarizing document. Is that something that was signed?
No, it was her. She had gone through some cancer treatment, everything subsequent to all that, and she could not say I specifically remember notarizing this document. Although Ms. Bosley did testify, and there was evidence admitted, she did provide her driver's license for the purpose of notary.
Okay. Just want to be careful. Any other questions, commissioners? Okay. Thank you, Mr. Bruce. Mr. Reed, I'll entertain a motion.
Mr. Chair, I'd like to make a motion that we adopt the PFD as recommended by the SOA judge with the minor correction that were stipulated to by Mr. Bruce. And that is my motion.
Is there a second?
I'm sorry, do you mean,
Stipulated by,
I'm sorry, this is Della. Do you mean the heading, the technical correction to the heading?
The technical correction
is Mr. Reed.
yeah, it's Mr. Reed. Yeah, so that's a correction. Thanks.
Oh, I thought Mr. Bruce stipulated to the correction.
I stipulate to the correction. Yes.
So we got the motion. We got the motion to accept PFD with the technical correction on both sides, stipulated, restipulated, stipulated again. God love us. Is there a second to that motion?
A second.
Okay. I'm going to do a roll call vote just for clarification. So, Tamla, you ready? Where you at?
Yes, sir.
Okay.
Vice Chair Butler,
Aye.
Dr. Callis,
Yes.
Commissioner Collier,
Aye.
Commissioner Castaneda,
You're on mute, Commissioner Castaneda. Say it again.
Aye.
Thank you.
Dr. Wesson,
Aye.
Figueroa, Chairman?
Aye.
Right,
Motion
the
carries.
ayes have it.
Thank you. Mr. Bruce?
Thank
Once
you.
again,
Good to see everybody. I hope everybody's safe up in Austin or wherever you are. Thank you very much.
Take care,
Thanks,
Mr. Bruce.
Thank you.
Thanks,
Thank you,
Mr.
guys.
Bruce. Appreciate it. Thanks for coming.
Bye-bye.
Thanks.
Thank you, Mr. Chairman, Commissioners.
Thank you,
Thank you,
Mr.
Mr.
Reed.
Okay.
Thanks for pitching in.
All right, we're going to item 3 of item I, and Ms. Hurtado.
Good morning, Commissioners.
Good morning. You have the floor.
Thank you. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. I request that you adopt the PFD as written, deny Brian Estrada's apprentice electrician license renewal application, and revoke that license. Mr. Estrada obtained his apprentice electrician license in July 2016. Then, on September 15, 2017, respondent approached a woman in a parking lot and asked her for directions to Walmart. While the woman was speaking to him, Mr. Estrada exposed himself to her and began to pleasure himself. The woman left the scene, reported the incident to police, and later identified the respondent in a photo lineup. In 2019, Mr. Estrada pled guilty to and was convicted of indecent exposure, a misdemeanor, and sentenced to 30 days in jail. The ALJ found that respondent's offense of indecent exposure is a guideline crime because it involves prohibited sexual conduct. When analyzing the factors in section 53.023 of the Occupations Code, the ALJ noted that the offense occurred approximately 3.5 years ago when respondent was 19 years old. While Mr. Estrada's offense was a misdemeanor, the ALJ stated that the offense is serious in nature because the facts indicated that respondent sought out his victim in a public parking lot. And while Mr. Estrada testified at the hearing that he regrets the incident and is embarrassed by his behavior, his only explanation was that he was experimenting at the time. The ALJ found the circumstances of Mr. Estrada's offense to be egregious and concerning, especially his tricking the victim under a pretense of needing directions. Additionally, the ALJ found that there was no evidence that respondent had engaged in any rehabilitation efforts to address his conduct. The ALJ also found that Mr. Estrada is not a good candidate for a restricted license at this time. The ALJ was not convinced that supervision by another licensed electrician would be sufficient to curtail Mr. Estrada's behavior in the future. And finally, the ALJ found that respondent currently lacks the honesty, trustworthiness, and integrity to hold a license. The ALJ recommends that you deny Mr. Estrada's renewal application and revoke his license. I ask that you adopt the PFD as written, and I'm available to answer any questions you may have.
Thank you, Ms. Hurtado. Any questions, Commissioners? All right, I'll entertain a motion.
Mr. Chairman,
Mr.
this is
Chairman.
Dr. Callis. I recommend that we accept the PFD and file as written.
Commissioner Collier seconds.
Excellent. Okay, we'll do a voice vote on the thing. So all those in favor say aye.
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 Any opposed? All right, motion carries. Thank you, Mr. Hurtado.
Thank you.
I think you're on with the next one. I think we also have a respondent on this case. Is that right, Ms. Tamla?
Yes, Chairman, we are trying to connect him now.
Okay, we'll give you a few seconds.
Thank you.
Mr. Chair, will I break the quorum if I run to the restroom real quick?
No, we're good. We're good.
I will be right back.
Mr. Chairman, can we handle the last case while we're waiting?
Tamla, how long do you think it's going to take?
He's calling in now.
Okay.
So I believe we could go ahead and do the last case. We'll just bring him into this meeting as soon as he joins.
You're okay with that, Tamla?
Yes, sir.
Okay. All right. We're going to stand by on item 4. On item I, we're going to go to item 5. And Ms. Hurtado, can you go ahead and, I think that one should fairly be quickly, but go ahead.
Yes, thank you. This case, the department has entered into an agreed order to resolve the matter with Ms. Munoz, and so we're just asking the commission to dismiss the PFD at this point.
Okay, Commissioner, I'll entertain a motion.
I'll make a motion to accept, dismiss the case.
Second.
I'll second.
Oh, excellent. All those in favor say aye.
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 Opposed? Motion carries. Okay. Tamla, you there? Mr. Roman, you there?
Yes, sir.
Okay, Mr. Roman. This is Chairman Figueroa. Okay, you're on our commissioners meeting. So I'm gonna read you some instructions. I want to make sure you understand, and then we're gonna go into it. Okay? Can you hear me?
Okay. Yes, sir.
Okay. Okay, we're gonna hear from the prosecutor first, and then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak. Tamla will keep time. You'll have up to 3-minute rebuttal if needed. Please understand that the commission can only consider information, this is important, Mr. Roman, information that is in the record when the case was heard at the SOA hearing. So you must limit your comments to those matters that were presented in the SOA hearing. Mr. Roman, do you understand?
Yes, sir.
Perfect. So you can stand by. We're going to get Ms. Hurtado to go first, and you'll have an opportunity. Ms. Hurtado, are you there?
Yes, thank you.
Okay, go ahead.
Thank you. Jessica Hurtado, prosecutor in the Enforcement Division. I request that you adopt the PFD as written and revoke Miguel Roman's Incident Management Tow Operator License and his tow truck company certificate. Mr. Roman obtained his tow operator license in January of 2014 and his tow company certificate in February 2018. On September 19, 2017, the Austin Police Department obtained a warrant to search respondents' home for drugs. Officers found approximately 91 grams of cocaine, as well as methamphetamines and other illegal substances. These drugs were found hidden inside food packages located in the respondent's kitchen pantry. And as a result, on May 7, 2019, Mr. Roman pled guilty to and was convicted of attempted manufacture and delivery of a controlled substance, a second-degree felony. He was placed on community supervision for 8 years. On November 6, 2019, respondent applied to renew his tow operator license, and he answered no to the criminal history question. Then, on February 11, 2020, the respondent applied to renew his tow truck certificate and again answered no to the criminal history question. Both of these answers were false. The ALJ found that respondents' attempted manufacture and delivery of a controlled substance offense was a guideline crime. Because of their mobility, a tow truck licensee would have the opportunity to receive, sell, or otherwise distribute illegal substances, including drugs. Similarly, as a tow truck company, respondent would have the opportunity to pressure other employees to engage in similar drug distribution activities. The ALJ considered the factors in Section 53023 of the Occupations Code, including that the respondent was 30 years old at the time of the offense, that he currently provides the sole income for his household, and that he was in compliance with the terms of his supervision at the time of the hearing. The ALJ also considered the testimony of respondent's partner, as well as the letters of recommendation he submitted as evidence. However, the ALJ notes that respondent's drug offense was recent, occurring less than 2 years ago, and respondent still has approximately 6 years remaining on his community supervision until May 2027. The ALJ concluded that not enough time has passed for respondent to establish a record of good conduct. Mr. Roman testified at the hearing that his false answers on the renewal application were a result of human error because he did not understand the question. However, the ALJ did not find this testimony to be persuasive. Mr. Roman had previously renewed his tow operator license in the past, and the ALJ found that he would have been familiar with the form and that he was aware of his felony conviction. Therefore, the ALJ found that there was no plausible reason why the respondent would have been confused in answering the criminal history question. Finally, based on his criminal history and his false answers on the renewal applications, the ALJ finds that the respondent does not have the honesty, trustworthiness, and integrity to hold the license, and therefore the ALJ recommends that you revoke Mr. Roman's tow truck operator license and tow company certificate. I ask that you adopt the PFD as written, and I'm available to answer any questions.
Thank you, Mr. Dodd. Any questions, commissioners? Okay. Mr. Roman, can you hear me?
Yes, sir.
Okay, you're going to have 5 minutes to respond. Again, I can't emphasize enough. Make sure you keep your comments to the SOA hearing if you don't mind, okay?
Yes, sir.
Go ahead.
Okay, hi, my name is Miguel Roman. So I would like to say that on the incident that occurred in 2017, you know, I didn't reinstate my license until 2018. So within the whole time of, you know, the offense, I didn't maintain a tow operator's license. So you can see from the day after I maintained my tow operator's license, as you know, when I started operating without no illegal, you know, offenses. But, you know, on the application, you know, it says, have you ever been convicted, or, you know, and I'm still kind of confused because I wasn't convicted at the time. I didn't get convicted till 2019, and the incident occurred 2017, so I put no. And I mean, it's just, there's a lot of confusion. I mean, and as of right now, let's say if I postpone this case, you know, 5 years later, do I still put no as an answer for have you ever been convicted, even though the offense occurred in 2017? And after being instance, you know, while operating, you know, it's given me great opportunity. Y'all fight is that I haven't had enough time. You know, within this short 3.5 years, you know, I've managed to build a company. I've managed to buy a house, pay off my tow truck. You know, always maintain financial responsibility when it comes to insurance. You know, I don't plan on operating illegal at all. And I mean, it's been plenty of time for me to look back. I mean, I've expanded my family. You know, my wife's a stay-at-home. And, you know, it's given me an opportunity to build myself, you know, maintaining this license. I mean, I'll do anything to keep it. Anything. I mean, I don't know, I mean, I take full responsibility for my actions. At the same time, it's like, I'll do whatever it takes, you know, to maintain this license for my company and myself.
Okay, Mr. Roman, anything else?
Yes. I mean, that's it, unless you have any more questions.
All right, look, I appreciate that. That's what I'm going to ask right now. Does any commissioners have any questions for Mr. Roman or Mr. Tata? Yes, sir, Dr. Callis. You're on mute, Dr. Callis.
Vice Chairman Butler was first, so I'll turn to him first.
Oh, thank you. Thank you so much, Commissioner Callis. Mr. Roman, how old are you, sir?
I'm 33 currently. I'll be 34 next month.
So I don't know how the commission is going to vote, but I'm going to tell you this, Mr. Roman. You have a lot of years ahead of you. Your past has brought you to this point. And my prayer for you, sir, is that you can tell us anything you want, but that you get on the straight and narrow and you stay on the straight and narrow, because now you have other people depending upon you. And
yes, sir.
I don't know all we have is you coming before us, telling us these things, but your actions are really going to determine the course of the rest of your life, sir. And so you can tell us everything that you think we want to hear, but your actions and the man that you become are more important than what you tell us here. So I don't know what's going to happen here today, but if you have a little one depending on you at home and a wife who's stuck by you through all the things that you've done and possibly put her through, you don't need to impress us, sir. You need to impress them by the life that you live. And so that's all I wanted to say, Mr. Chair.
Dr. Callis.
Thank you. Thank you.
Mr. Roman, hey, this is Commissioner Callis. My first question to you is, before this incident where you are possessing and distributing a large amount of narcotics, have you ever had any other trouble with law enforcement?
No, sir, never.
Since that time,
you can look at my record.
No, I trust you. I'm just asking you. I'd rather talk to you instead of looking at a record. Number two, since that time, it really sounds like you're passionate, and I agree with Vice Chairman Butler says. You can say whatever you want to us, and you can try to make us believe a story, but the only way I believe things is by action. And your actions are going to speak louder than your words. I will tell you that I am shocked that it sounds like you're doing a lot better, but I'm shocked that whenever you decided to do this, that you sounded like you were already a strong adult and you already had a credible profession going. So I don't know how you'd make that decision in the first place, but that's not for me to decide. My decision is deciding on what I'm going to do with your license. My final question is for you is, since that time, have you done any type of drug rehab, or have you done anything to make sure or educate yourself to promote your safety, your family's love and commitment, like in a rehabilitation type setting? And I know I'm getting personal because this is a personal decision I'm getting ready to make on your license.
Yes, sir. I've been to rehab. I've been to classes. I've had to deal with CPS because of the situation. And, it's one thing, when you're allowed to see your kid once every 2 weeks in a visitation room for an hour at a time. If that doesn't make or break you, I don't know what will. And I refuse to go back. You'll wreck driving, looking in the rearview mirror. And I refuse to look back and just move forward and, be a positive role model for my kids and my family. This has gave me the opportunity to do it. There's been so many things that I've overcome and done and accomplished because of this license.
Thank you. Thank you, Mr. Roman. I agree with what Vice Chairman Butler is saying, but the one thing that I definitely don't want to do is put you and give you a professional license again, just because you're telling us something here, and then citizens in the great state of Texas get harmed by our decisions we make today. But I'm also a physician. I also listen to people every day. And you know what? God didn't create us to not make mistakes. So I appreciate your honesty and your integrity. Chairman, that's all I have.
Thank you, Dr. Cal.
Thank you.
Mr. Chairman, Commissioner Collier, and along the lines of thanks, Dr. Callis, for mentioning about the training courses and rehabilitation, because that was one of my questions. For the letters of recommendations that I see on page 9, when were these forthcoming? When were these written? Mr. Roman or who's our attorney?
These were
Jessica.
done.
Mm-hmm. Go ahead, Mr. Roman.
I don't have the paperwork in front of me. I don't have the paperwork in front of me. This was last year. These are written.
Okay.
July 2020.
Right before my last. Okay, right before my last hearing.
They were written in July and August 2020, Commissioner.
Mm-hmm. Okay, thank you.
The date is that. I'm not sure what that's what the date's on the letter. Any other questions?
Yes, is Della on the phone? Yeah, I see that. Della, can we do a restrictive? Can we do a restrictive license? Is that something or no? I just want to know.
No, not in this program.
Thank you. That's all I wanted to make it clear before I listen to someone's motion. Thank you.
Chairman, may I make a clarification?
Go ahead.
Yes, thank you. I did want to let the commissioners know that Mr. Roman, he did have another offense in 2012. It was ultimately, he was arrested for a DWI, but he was ultimately pled to an obstructing, and that was in the record, but the ALJ found that that it wasn't a relevant crime for this license, and so that's why it wasn't in the presentation. But since Mr. Roman did indicate he hadn't been in trouble before, I wanted to bring that point to the commissioners.
So the obstruction of the highway is what you're referring to?
Yes, yes, ma'am.
Yeah, okay. Okay, Dr. Callis, I know that you're kind of dancing around this. Let me give you some arrows that you have available. Probated, suspended license. These are things. So if you have an idea in your mind that you have, you can articulate that to Della or Charles. I'm sure we can figure the right verbiage for it. But if that's what's so, I'm not telling you do it or not do it. But if you're dancing around that, the restricted license is in our arrow in our quiver, but the probated, suspended license are. So just that's an FYI.
All right, well, I appreciate that, Chairman. I'll yield to Vice Chairman Butler. I think he's going to make a motion. My concern is, and I just want to go on record as saying this for Mr. Roman, I don't like to be fooled by rhetoric whenever we are going down a path. I'm very open to rehabilitation, and I believe in that because I've taken physicians and made them go back to being physicians even after big time drug offenses. And so, but what I don't want to do, and I'm trying to make it very clear to all of my other fellow commissioners, is that I deal with drugs and rehabilitation all the time. I give narcotics every day. And my concern is that I want to give everyone the benefit of the doubt, and I don't want to be fooled. So that's why I was asking you, Chairman. I want to make sure we had some bite in this if we decide to go down a path, because I don't believe in just saying, okay, no big deal, just sweep it under the carpet, let's move on. So that's what I was asking. Thank you very much.
Yeah. If I may, Mr. Chairman, I just want a clarification again. I do understand that the one recommendation that's dated July 27th, 2020, I see that letter. The letters of recommendations, I guess that's highlighted on page 9, did those come in as well? Is that the same time frame, or is this something earlier? And then for Mr. Roman, for the training classes and rehabilitation, are you in such type of classes now, or if you can give a timeline?
No, I'm in no classes as of right now. I'm a firm believer in actions speak louder than words, and I mean.
And when was your last class?
Pretty far in life.
Excuse me, when was your last class? Thank you.
I would say maybe 2 years ago. It's part of terms and conditions on my probation, and as for my probation, I can possibly get an early discharge 2023 at the halfway mark.
Okay.
Question, Mr. Chairman.
Full 8 years.
Just my last question, Mr. Chairman. And so I understand adhering to your terms of probation. Did you take any classes outside of that particular criteria?
I did take there's a lot of stuff that I had to voluntarily take, just for my own doing, just to understand, the situation. But yes, I mean, I have taken classes outside.
This is Della.
Anything to better myself.
Yeah, this is a little outside the show here, but go ahead, Della.
I just want to make sure, Jessica, that we make sure that we stay in or Mr. Roman, what was discussed at the hearing. I don't recall classes discussed.
Right. Commissioners, I'm gonna give you a little latitude on this, but again, we got to stay with that. For your answer, what I have on file, Commissioner Collier, is 3 letters. A recommendation, one's August 11, 2020, July 27, 2020, and July 26, 2020. So just in response to your question about the date. Again, Commissioners, we got to stay within those confines. I hear dancing. I want to make sure you understand. If you have in your mind what you would like to do, you can articulate that to our council, and we can maybe get that motion, whether it approves or not. It's up to y'all. But any other question? I want to hear from Commissioner Castaneda, Wessons.
Hi, it's Commissioner Castaneda. Are you presently being tested for drugs?
Again, I'm not sure that was discussed at the hearing.
Okay, so we're
Am
gonna
I
hold on.
currently being tested?
Yeah, I think, hang on, Mr. Roman. So Della, what are you saying again? I'm
Okay.
sorry.
Testing, I'm not sure that was discussed at the hearing at all.
Okay, let's put a bookmark on that one.
We just got
I
to
know
be
it's
careful. We're admitting new evidence in, and we shouldn't be doing
right.
that.
Well, Della, I have a question for you. This, to me, that's pretty relevant to make. I mean, I don't understand how, if we're trying to make a decision, because that was my other question, is that if you're doing randomized drug testing, that is also protecting the citizens of Texas. And so I think that's what Commissioner Castaneda was probably trying to get to. And I respect what you're saying. It's not the SOA hearing, but that might help us make a decision as we move forward too.
If I may, let me, Chairman, may I ask a question or two?
Just stand by, Mr. Burlow, because we got a lot
Yes,
of moving parts. Ms. Francis, you had something you want a point of clarification?
Yeah, Mr. Chairman, again, we do have to be careful what's on the record and what's not on the record. But there may be a way to frame the question and identify what is in his terms of probation. And so if the probation or his, if those terms include testing courses, I think asking those questions, because that was admitted in there, and just digging through that, I think that may be appropriate.
Yes, sir.
Okay, Mr. Butler, go ahead.
Yes, sir. I was a probation officer for about 6 years. So I'm going to ask this question. Mr. Roman, under the standard conditions of probation, because I see that in the public record at the SOA hearing, you are under community supervision, correct?
Yes, sir.
Okay, that was brought into the SOA hearing. The standard conditions apply to most people, and that's generally drug testing. Do you fall under that category of standard conditions?
Yes, sir. I take random drug tests all the time.
Okay. So, Mr. Roman,
I have no problem applying on that.
Yes, sir. With the chairman's indulgence, I'd like to make a comment and then make my motion. Is it appropriate, Mr. Chair?
Before you make the comment, before you make that motion, we'll give everybody else ability to reconcile their thoughts. So, but yes, Mr. Butler, go ahead.
Okay. So, Mr. Roman, you have been blessed in your life. You have been blessed to be born in the United States. You have been blessed to be born or live in this great state of Texas. You've been blessed to have people from diverse backgrounds looking at your case right now and talking to you. And they're rooting for you. They want the best for you. And what Commissioner Callis said, actions are more important. And I think it's time to grow up at this point. You're 30 years old.
Yes, sir.
The blessings that hold on one second, please, that you've been given, it's time to make something of that. Okay. It's time to stop taking from life and start giving. You have a child, you have a family, you have a career that could potentially take care of that family for the rest of your life. So my motion to you, and I don't need to hear any more words from you. I'd like to see actions. I would like to revoke your license and then suspend that revocation. I would like to make a motion that we deny the PFD or accept the PFD, revoke your license, then suspend that revocation to allow you to work, but we will be watching over you. I think you answered the question incorrectly. You're a grown man, a very smart and articulate man. I could only think that you probably may have done that on purpose. I'm going to ask that we assess a penalty of $1,500 for you doing that. And that is my motion, sir.
Okay. Mr. Butler, I want to clarify on your motion real quick, and then I want to give other commissioners their last try. So what you're saying is you want to accept the PFD for the revocation, then suspend that, correct? And then
yes, sir.
You mentioned the word, we're going to watch over you. What does that mean? Is it a term that you're, a time period that you're looking at, or?
I think, Mr. Chairman, I'm glad you said that. My thought was the remainder of his probation to run concurrent with the community supervision that he's on by the District Court 133 out of Travis County.
Okay. So for the remainder of the probation, and then you're going to assess a $1,500 penalty.
Yes, sir.
For this one. Okay. Della, you're going to have to unwind the spaghetti a little bit.
I have just a few things to say. Obviously, if you're going to change if you if your will is to change what's in the PFD, we'll need to talk about which findings of fact and conclusions of law you'd want to do differently and explain why. So we have what could be changed legally would be finding of fact 10 and 14 because they're more like conclusions, and conclusion of law 12, 18, and 19. We'll need some justification, and I think what I've heard from you, we could probably articulate that in an order. I don't believe we're able to assess a penalty in a criminal denial or revocation case.
Okay,
But we
so
could extend, we would need to know also how long to extend the suspension for Mr. Butler until the 2027 term or until his criminal probation ends. We would need some kind of ending.
So I have 2027 here, but it may end early. And if it ends early, that's because he's doing everything he's supposed to be doing. The drug
Right.
screens come back clear. He's done the testing. So is there a way to square that circle and make it run concurrent with the community supervision? He can tell us, and then we could check possibly if community supervision is ended. And I, for the life of me, why can't we not assess an administrative penalty if we find that that he answered a question incorrectly?
Well, as far as I know, it's not a violation, but we can certainly take that into consideration.
I think there should be some. Wait, Mr. Francis, please.
This is Brian Francis. Dilla, I think the violation would be honesty, integrity, and trustworthiness. We still have that component of them not being honest on the application. I think we can probably dovetail it into that.
Dilla, this is Christina. There would also be a violation for falsifying information on the application.
Okay. Okay. I was just thinking of the criminal offense. I apologize. Yeah.
Right.
Okay.
Yeah, it's easy to merge the two.
So we're going to tie that 1,500 to the application. And basically is what we're doing, correct?
Right. Not to the criminal offense.
Correct. Correct. Okay. Okay. So
and that's open for discussion, Mr. Chair. If my fellow,
let's make sure we understand what we're discussing first. I want to get your motion clear. So what Della, you admit that we're going to not accept the PFD because of fact finding number 10
and 14. 10 and 14, you would want to amend or change finding of facts number 10, 14, conclusion of law number 12, 18, and 19.
18, 19.
And then articulate the reasons your justification, which we believe sounds like because of his ongoing adherence to his criminal, probation and other things.
Rehabilitation, essentially.
So your stipulation is because of his rehabilitation, his probationary conditions. This is a reason why you're finding issues with those fact findings and those stipulation. Okay. And then we got the numbers 12, 18, and 19. And then let me make sure just 14 and 10 on the findings of fact. Okay. And then we're going to assess the $1,500 penalty. What Mr. Butler would like to do, Commissioner Butler would like to assess the $1,500 penalty on the false application. Correct?
Yes, sir.
Okay. All right.
I believe you'd want to, we're going to revoke and then probate the revocation. I know you keep saying suspend, but we're going to probate the revocation for a certain amount of time. Okay.
Probate. Got it. Got it. Revoke and then probate the revocation. I'm going to probate over. Okay, that's the motion. Any discussion? I'm going to give everybody a little latitude on this one because there's a lot to it. So any discussion?
I have discussion, but I don't think I can discuss until we second Vice Chairman Butler.
Is there a second?
Commissioner Collier seconds.
Okay, go ahead, Dr. Callis.
Yeah, Della, I have a question because I think Vice Chairman Butler eloquently said exactly what I was thinking. I agree with the PFD. I totally agree with everything stated in the PFD. what we're saying, and I think what Vice Chairman Butler was trying to say, is that I don't want to change the language in the PFD. We all agree with the PFD. What we're trying to say is that the ALJ wanted revocation. We're saying we don't want to go that strong. We are agreeing with everything the PFD said. We want to definitely assess an administrative penalty for forfeiting an answer that was not credible on his application. But also, I'm just telling you, I will vote no for this motion if we're changing the PFD, because that's not the intent of Vice Chairman Butler, what he was trying to do.
Okay, there's a few that we would need, there was a few conclusions of law that we would need to change in order to allow him to just not be revoked straight up.
That's fine, but I'm just saying, I understand what you're trying to do, but I understand what Vice Chairman Butler's saying, and I respect the ALJ's decision. That's all I'm trying to say, is that I'm not trying to become an attorney. I'm not trying to become a judge. I got the facts in front of me, and I'm trying to keep the PFD as strong as it possibly can to make it to where he's just trying not to throw the sledgehammer. He's trying to show rehabilitation as an option and a fine. But I think we all will accept the PFD. That's what I think I'm trying to make sure that, and I'm not trying to confuse you. I just want to be able to say that I agree with the PFD, I agree with the ALJ, and I totally agree with Vice Chairman Butler's comments.
Right, and you'll still be revoking, which is what she recommended, but there will be a few tweaks as we set out, just to lay out the fact that it's not going to be a full revocation.
Thank you, ma'am, for your explanation. But I just had heartburn whenever I'm hearing that we're going to change all this PFD whenever we're not even saying to change it, because we agree with the PFD. He's just trying to decrease the sentence, just like we would do in a trial. Just because you can get a death penalty, you might only get 40 years. That's what he's trying to do.
Right. So, well, let's try not to think of it as rejecting the PFD or not agreeing with it. We're amending it.
Thank you, ma'am. That's a lot clearer. Yes, ma'am.
Dr. Callis, to that point on the fact finding, I guess the conclusion of Law 12, it's counterintuitive in a sense of not currently fit to hold an incident management total like that. So that's counterintuitive because we're probating that sentence. So I think I agree with you completely that the stipulations in the PFD are something that we can agree on but that contradicts the actual results of what we're trying to do. So we have to tweak it to allow that probated sentence.
Yes, sir. I hear what you're saying, but I just want to go on record saying that we agree with the ALJ and we agree with the PFD with little tweaks. We're not saying we don't agree with what was decided. That's what I think Vice Chairman Butler was trying to say that, and I just wanted to get it off my chest so I can have a clear conscience when I make my decision.
Right. We're just amending it.
Right. And to your point, the very last conclusion of law, which is 19, that's, in my opinion, Dr. Callis, please correct me if I'm wrong, we're agreeing totally, we're just probating that revocation. So at the end, the conclusion was revoke that license. You're just saying we're adding that. So is that accurate?
Very accurate, sir.
Okay, so that's one that he wants to hang his hat on, and I think as commissioners, I think Commissioner Butler's in that agreement as well, right? Okay, so Della, did you get that?
Mm-hmm. Yes.
Okay, perfect. Okay, any other discussion on this?
So we've made the motion with.
Yes, it's been a second.
Are you asking me to make the motion again?
No, sir. No, sir. No, don't do that. We've got a motion. We got a second. Stand down here on, and I just want to make sure everybody, because there's a lot going on, there's opinions going on. I want to make sure every commissioner has an opportunity to speak on this. And yes, sir, Dr. Wesson.
I just wanted to go on record that, in statement of facts, he got his license back in 2018. His most recent criminal offense was what he pleaded guilty to in 2019, but he answered the question incorrectly on 20. And we've had cases like this before, and it just seems to me that we're going all around the circle here, trying to figure out how to change what the law actually requires that we voted on before. And, I'm going to vote no on that.
Dr. Wesson, any other comments? Okay, so we have a motion and we have a second on this motion. Does anybody need clarification on this motion? Commissioners, raise your hand or wave at me.
Sure, Mr. Chairman, why don't you clarify No, I'm just kidding.
Okay. You bet. You bet, Dr. Miska. And I'm tearing up your recognition paper over here, by the way. What we have is, and Commissioner Butler, please, and Della, please correct me if I'm wrong here, but what we're trying to do is we're going to agree with the PFD to revoke the license. We're going to probate that revocation, okay, under the terms of the probation of licensee, Mr. Roman, and then we're going to add a $1,500 fine because of the false application. Is that correct, Della and Tom?
Yes,
It
sir.
is, and I can add one thing. I think the $1,500 the $1,500 is below what is recommended in our plan, but you have the right to assess whatever penalty you want, but it's below the recommended plan that the department uses, which is 2,000 a minimum, I think up to.
Okay. Okay. So I'll give you a Commissioner Butler to offer a friendly amendment if you want to modify that 1,500.
Yes, sir. If that's what our guidelines recommend, we're $500. I'm happy to amend that. I wanted the carrot and the stick, and so it's yes, $2,000. That's what we call for. We voted on it. Let's go for $2,000.
Okay, so we're going to amend that. Are you okay with that, Commissioner Collier? You second the motion?
Yes, I'm okay with that. Thank you.
Okay. So how you like me now, Commissioner Collier? All right. So I think we got it all set up. $2,000. We're going to adjust it to $2,000. Any other clarification? All right. I'm going to do a roll call vote for this. I'm sorry?
No, I mean, no.
Okay. Yeah, Dr. Callis.
This has nothing to do with this case, but I agree with what Dr. Wesson just said. I think we need, because it's hard for me to decide if someone's being honest and trustworthy or they really don't understand the question. I think that this needs to get dug into, because I think that we go on a case-by-case basis, but I do agree with what Dr. Wesson is saying. I just wanted to say, Mr. Chairman, I think we need to look into that, because we do deal a lot with people not being dishonest, or being dishonest, but actually not understanding, saying yes or no if they've been convicted. I think it needs to be a little bit clearer in the sense, because we'll talk later. I'll be quiet, but there's a lot I want to say.
Right. I think your point is noted. I'll make sure the staff notes it. Mr. Francis, you got that, and we'll look into that clarification on that point. But the motion still stands as is. Any confusion on that motion?
Ask for a roll call, please, Chairman.
Yes, sir. I'll get you. All right. We'll do a roll call. Tamla?
Yes, sir. Vice Chairman Butler,
Yes.
Dr. Ray Callis,
Yes.
Commissioner Helen Collier,
Aye.
Commissioner Nora Castaneda,
Yes.
Dr. Gary Wesson,
No.
Commissioner Figueroa.
No. Okay. Motion carries. Mr. Roman, can you hear me?
Yes, sir.
Okay. There was a lot of words that were exchanged here, but let me try to put this as succinct as I can to you. And I want to make sure you understand. What we're doing here is we're agreeing with the PFD on the revocation, and we're going to probate that revocation. We're going to apply a $2,000 fine because of the false application information. But all that is to say this: you've been given an opportunity. Okay, the staff will clarify a lot of this stuff for you, but you've been given an opportunity. I cannot be more emphatic about that. That opportunity is not something that's granted lightly, and it weighs heavy on the commissioners, because they are putting their name next to yours in a sense. So I want you to be as clear, clear to you as possible, that what happened today was an opportunity for you. And Commissioner Butler referred to it. Many Dr. Callis and Commissioner Collier referred to it. A lot of them did. But I want you to understand with certainty that this is not a very common circumstance. It is rare. And so by that, I want you to go forth knowing that you basically won the lottery. You got that, Mr. Roman?
Yes, sir.
Okay.
If I may, Mr. Chairman, Mr. Roman, this is Commissioner Collier, and clearly, as Mr. Chairman said, that this is an opportunity, and we do not take it lightly by any means. And rest assured that if the direction going ahead is a straight line, if you should curve off that line, then you
Never.
know coming back before this commission what's going to take place.
Okay.
Mr. Roman, you're dismissed. Tamla, I think that's our last case. Is that accurate?
Yes, sir.
Okay, good. Thank you so much. Okay, we're going to go on to the rules. Item J. Let me get my eyes here. Okay. Vehicle towing and booting program. Ms. Strittmeyer.
Good morning. I think it's still morning. Yes, good morning.
I think it is.
My name is Elizabeth Salinas Strittmatter, and I am the Assistant General Counsel who works on the tow VSF program. We're presenting here today an amendment to Chapter 86, specifically Rule 86.700. 86.700 is being amended to address the issue of flipping, which the Commission has talked about this morning. And just very briefly, flipping is the act of a tow company taking a vehicle that's been involved in a non-consent tow, usually in an incident management tow, from an accident scene to an unlicensed facility, usually a body shop, instead of to a licensed vehicle storage facility. This is a problem that the Commission has been made aware of for a couple of years. It's been growing in its propensity, and we were asked by the board to look into whether we could amend our rules to specifically prohibit flipping. So that is what this particular rule does. The rule specifically prohibits the towing of vehicles involved in an incident management or other non-consent tows to locations other than those stated in rule. In rule, it's only allowed to go to a licensed vehicle storage facility. Recommending that the vehicles be towed to any location other than the licensed vehicle storage facility. So it prohibits the tow company or a tow operator from suggesting or recommending that a consumer allow their vehicle to be taken to a non-regulated entity such as a body shop. And it prohibits the tow companies or the tow operators from obtaining authorization from the vehicle operators for repairs or any other fees other than those that are required for the tow itself. So this is a rule, as I said, that we had industry support on. It was published on December 18th, 2020. Public comment ended on January 18th of 2021. We had a total of 5 comments. One of those comments did not relate at all, so it was forwarded on to the appropriate division for handling. It was a question rather than a comment on the rule. Of the remaining 4 comments, 2 were support of the rule and 2 criticized specific portions of the rules. But I would note that when we presented this rule to the board on March 16th, there was a unanimous vote to take this rule as written to the commission. So we are asking that you approve the proposed rule as currently drafted with an effective date of June 1st. And I'm available to answer any questions if you have any.
Questions from Ms. Strittmeyer? Matter. Sorry, working on it.
No questions on my end, Mr. Chairman. I can make a motion to accept the rules as presented.
Second.
Second.
All in favor, say aye.
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 Yeah.
All right, motion
This-
opposed? Good, motion carries. I'm going to allow everybody to take a break because we're going to have an extensive staff report. So it is 10:38 right now. I'm going to say we adjourn at 10:45. Just take a quick break. So
Sure.
Della, are you there?
Hey, Brian, as you can take a break.
Commissioner Cowles,
Sorry.
something you want?
No, I didn't see Elizabeth anymore. I just wanted to, commend on the rules. This is huge and important. Huge and important.
Right.
Huge
So
and important.
Thank you.
we're going to take a break. We'll convene back here at 10:45. Della, you there?
I am.
Out of sheer hope, is it okay if we just turn our cameras off and mute and then come back in, or do we need to log out?
It depends. You mean just go on mute? Yeah, that's fine.
Okay, let's do that, and then we'll convene at 10:45. Okay. All right, time is 10:47. Call the meeting back to order. We're going to go to item K. Beverly, Miss Beverly, where you at? There you are. Okay, item K on the rules section.
Yes, I'm Laura Pefferly. I'm Assistant General Counsel in the GC Division, and I'm presenting the amendments to the rules for behavior analysts. These rules are at 16 TAC, Chapter 121, Section 12110.21.22.70.75, and a new rule section at 121.71. And these are for the adding the telehealth minimums and standards for behavior analysts who practice using telehealth. They have practiced with telehealth for a number of years, and this is just putting into statute or into rule what their minimums are. The rule was published on December 4th, and then the comment period closed on January 4th of 2021. And there were 3 comments generally in support, but 2 expressed some dissatisfaction with the use of the word experimental in relation to the technique of using telehealth to deliver a behavior analysis service. The behavior analysts generally use the word experimental when there isn't a large body of evidence that a technique is effective when delivered using telehealth. It's not that the technique isn't effective, but if telehealth delivery has not been solidly established, they're comfortable with the use of it, the word experimental, but some of the commenters did not feel like that word should be there. So there were 2 minor wording changes to just remove the word experimental. They still need to be truthful with the client about the effectiveness of telehealth as a delivery method. And so the board was in support of making those 2 changes. And the other minor issue with this rule was that the proposed rule was published with some of the text in that new section marked as new text instead of moved text. Some of the text had been moved from another section into that new section, and then the rest of that section was the new telehealth material. And so the proper wording was there. It was just published as if it was new instead of moved. And the preamble did explain that that text had been moved. And so we feel like that there's no reason not to, to change our recommendation to adopt the proposed text with those 2 minor wording changes regarding the word experimental that I already described. And the effective date would be June 1st of this year. And if you have any questions, I'll be glad to answer those.
Hi, Laura. This is Commissioner Collier.
Yes.
Great seeing you. Thanks for your support with this effort. Really appreciate it. I know that I probably moved through this pretty quickly. I do not remember where the words experimental, but they've been removed from the document already that I have.
Yeah. Yes, we hadn't changed the meaning. We just didn't require them to use that term experimental. They just, yes, they need to continue to be honest about the fact that the telehealth delivery method may not be as well established as the technique itself.
I understand that. And where was that in the ruling? Because I do not recall. Where was that?
That was all in that new section 121.71.
Okay.
And yeah, in A and in D.
Okay, I might have. Okay, got it. Okay, thanks. I'll reread it.
I had a comment for you. I just want to say thank you for taking out the word experimental. There's nothing experimental related to telehealth. We've been doing this all the way back whenever Alexander Graham Bell got a phone and was able to dial in. So there's nothing experimental about this. I think that the problem is going to be on the provider side, which you hit the nail on the head. Trustworthiness is due to the fact that some people can get very lackadaisical and not deliver the care that they're trying to deliver. I will also inform you too that telehealth and telemedicine and the profession of the practice of medicine, the first people to ever go live were psychiatrists. So just to let you know that the word experimental, thank God you took it out, and thank you for what you do. And I think that what we're doing is that we're crawling before we can run, but we also are making sure the behavior analysis and everyone that touches a patient make sure that they are honest and trustworthy. But thank you very much, and I totally support.
Thank you.
Thank you, Dr. Callis. Your passion is noted. Any other comments? All right, Dr. Callis, you want to make a motion?
I'm making a motion to approve these rules.
Second. Okay, go ahead.
Second, there's been a motion. It's been second. All those in favor say aye.
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 Opposed? Okay, motion carries. Thank you. Appreciate
you.
that. Okay, we're going to go to item number L. Is that correct? Make sure I'm standing in three. Yes, at item L. Mr. Gladney.
Good morning, Commissioners. For the record, I am Mark Gladney, Assistant General Counsel, and I'm here to present for adoption a rulemaking amending the fee associated with the criminal history evaluation letter in Commission Rule 16 Tax 60.42. This is a small change to the rule, but important in its potential impact to our citizens. This proposed rule reduces the current fee amount charged for a criminal history evaluation letter from $25 to $10, which will aid in removing a potential financial obstacle for a significant number of Texans who are seeking an opportunity to obtain an occupational license. The proposed rules were published in the Texas Register on January 22nd. The comment period closed on February 22nd. The department received 4 comments and none were in opposition to the proposed rule. The department asked for a motion to approve adoption of the proposed rule change at 60.42 as published with an effective date of June 15th. Thank you.
Thank you, Mr. Glad. I want to make another comment. TPPF, which has been a tremendous partner with us in getting things done on various levels as far as this. They had made a note, and Rod Borland is a very good friend of mine, and he basically, I'll read this verbatim in his note. As we've noted in the published proposal, the impact of the reduced fees is particularly beneficial to those that with fewer financial resources and could help remove the barrier to licensure and improve our opportunity to seek such licenses in the future, which basically means that I cannot tell you how important it is to go hand in glove with TPPF and getting things done. It is a Herculean effort to get things done, and they have been very well and lean to that effort. So I want to recognize that. Any other discussion?
Yeah, Mark. Yes. Oh, sorry. Go ahead, Brian.
I'm Brian Francis, Executive Director with TDLR. I just want to commend you and the commissioners and then my staff. This is something you've been pushing indirectly, which is can we find more ways and new ways to facilitate second chances. And one of the big hurdles that a person has when they're recently released from incarceration is financial means. And having a 60% reduction in a fee may not sound like much to us. To those that are in those dire straits, it can mean the difference between getting a can of milk, getting some diapers for your child, and trying to go forward with your career. I want to thank Christina Kaiser, Mike Ayers-Mendez, and their staff for continuing to just sift through all of our rules and our possibilities and bringing these type of ideas forward. And Mr. Chairman, your leadership in second chances has been just great, and it pushes us. I feel your push on my back every time we're looking at a rule. What's going to be the impact? Are we putting barriers in place? And that's a good push. It's a good push. So thank you, and commissioners, thank you all for your support in these type of initiatives.
I had a quick.
I think Chairman's on mute.
Oh, I just was going to ask, in one of the comments it said about doing this online, as opposed to doing through the postal service. I've taken 4 days to get something from Richmond to Sugar Land. So I was just wondering if that's ever a possibility for the department to look at that later on.
Well, I'll tell you what, we'll put it on item D as us solving U.S. Postal Service problem. We'll work on that. Noted.
Yes, sir. Dr. Wesson will look into it. And Mr. Chairman, if I could add one more thing. When you look at the landscape of all occupational agencies are dealing with this requirement under Chapter 53, the majority of them are assessing a fee of $50. We were already lower at $25, and to take this down to $10 is really stepping out and taking the lead in this area. I shared it with my other 21 executive directors I meet with every other week, and I said, we're gonna put a little pressure on you. We all have to.
Mr. Chairman, I got a question for Mr. Gladney and for Mr. Francis.
Yes, Dr. West. Dr. Kyle.
The first question I have is what was the benchmark going from $25 to $10? That's my first question. So I know it's a 60% reduction, but why did we say $10? Why not $5? Why not $3? I mean, so that's my first question. Number two, what is a budgetary constraint from dropping from $25 to $10? Because, I know we found $3.2 billion more in the rainy day fund by Glenn Hager, but it's still cutting our agency by going from $25 to $10. And I want to hear what the fiscal impact is going to be prospective.
So this is Brian France, Executive Director. On average, in the last 3 years, we've had about 500 folks that have sought this. So that's about $12,500 in revenue. When you look at the 500 at $10, it's going to be 5,000. So that's not going to adversely impact our revenue stream. $10 was that round number, and Dr. Callis, to be frank with you, we didn't do a cost benefit analysis on that. There is an opportunity for us to take it lower, and we'll explore that.
Well, the reason why you hit the nail on the head, since it's such a small, minute number in the whole scheme of things, and we're giving Texans more opportunity to maybe hold a professional license in a career, I think spending or sacrificing TDLR after you look at it, I'd like to entertain and see if we can even probably do something that no other entity will be able to do. And so I'm just putting it out there, and thank you for your comments, sir.
Good comments, Dr. Callis.
Yeah, Mr. Chairman, this is Commissioner Collier, and this is clearly, continues to be in the right direction. Mr. Francis as well, commend the staff for this effort and continue to move forward. I know that we use the contemporary term of second chances. I'm a believer in providing as many chances as long as Texans are hustling, doing the right things and coming to the table with a heart and a passion. So this is in the right direction. Cost benefit analysis is, good question, Commissioner Callis. And I think in your comments, it's circling back as to what it really is going to mean for the state of Texas for folks to be able to get licensed with this effort. So thank you for this effort.
Mr. Chair, if I may.
Yes.
I like the tenor of this conversation. I like the idea that we're considering, what Dr. Callis just said. Why a license fee at all? I mean, it has me thinking, are we creating a burden to any Texan trying to get licensed? Maybe we should start assessing fees 6 months after their license and do away with upfront licensing just so they can get to work faster. These are things that we need to talk about. These are wonderful ideas. So anyway, let's keep it going. This is great.
Absolutely. This has been a big part of that opportunity to re-engage people that are disenfranchised. But Brian, let's put this on an agenda item to talk on this on a bigger issue. So do I hear a motion on this rules?
I make a motion to support these rules by Mr. Gladney, who laid out perfectly.
And I second that, Commissioner Collier, and that's with the June 15th date. Is that correct? Or is it June 1st?
June 15th is
Okay,
the effective date.
Thank you.
All right. All those in favor of that motion, say aye.
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 Opposed? Good. Motion carries. Thank you, Mr. Gladney. I appreciate your time.
Thank you, Commissioners.
Mr. Burkhalter. Item M.
Yes, sir. Thank you. Good morning. My name is Derek Burkhalter. I'm an Assistant General Counsel for TDLR. This agenda item M deals with proposed rules for the Dyslexia Therapy Program at Title VI of the Administrative Code, Chapter 120. Just to summarize the major changes to these proposed rules, they would update the licensing requirements in Section 120.21 and .22 to allow individuals who are certified by the Academic Language Therapy Association, which we'll call ALTA, to apply for a license without being required to provide the department a diploma or transcript proving their education. These documents are already required by ALTA for its certification, so it is redundant for these individuals to submit these documents to the department when applying for a license. Another change, the proposed rules update the designation of the examinations required for licensure, and this would reflect the change by ALTA to the names of the examinations it administers. Here's the recommended language before you today in Section 120.23 differs from the language that was published in the Texas Register. So rather than have the rule refer to the specific names of the exams, we've changed the rule to just refer to, quote, the examination administered by ALTA. And this will allow for future changes to the exam without TDLR having to amend our rules each time. Another change, these proposed rules allow the human trafficking prevention training course, which is required for license renewal, to count towards up to 1 hour of continuing education credit. Finally, the proposed rules remove the prohibition on providing services solely by telecommunications. This is in Section 120.90. This particular provision was suspended by the governor's office to allow telehealth services during the COVID-19 pandemic. Removing it permanently from rule here would allow licensees to conduct services solely through telehealth without the necessity of an initial in-person meeting as the current rule requires. These proposed rules were published in the Texas Register on December 4th, and the public comment period closed January 4th. We received no public comments. The Dyslexia Therapy Advisory Committee met on February 24th and recommended adopting the proposed rules with the changes I noted to Section 120.23. The department recommends the commission adopt the proposed rules as recommended by the advisory committee with an effective date of June 1st. And I'm happy to answer any questions you may have.
Any questions, commissioners? All right, I'll take a motion.
I'll move, Mr. Chair. We accept the rules as proposed.
Second.
Got a move in second. All those in favor say aye.
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 Opposed? Motion carries. All right, Mr. Burkhalter, you're on item N as well.
Thank you, Mr. Chair. This agenda item N concerns a new emergency rule to enable the executive director to issue emergency licenses to license holders whose licenses expire during a state of disaster declared by the governor. As you know, the COVID-19 pandemic caused the department to experience a backlog in the processing of license renewal applications and other functions. The previous emergency rule to address the backlog became effective November 23rd, 2020, and it will expire May 21st, 2021. Because the department continues to experience delays caused by the pandemic, despite significant progress in streamlining department processes, this new emergency rule is necessary to ensure our licensees, many of whom provide essential services, do not experience lapses in licensure through no fault of their own. The department recommends adoption of this new emergency rule with an effective date of May 22nd, 2021. It would be in effect for up to 120 days and may then be renewed for up to an additional 60 days. And with that, I'm happy to answer any questions.
Any questions? Good. All right. For that, I just want to tell Mr. Francis and staff's done an extremely great, incredible job in this pandemic in regards to responding, and we have learned so much and on how we can operate more efficiently. Right. I cannot emphasize necessity is the mother of invention, and I mean we were a necessity, and I can't commend and we're not going to unlearn these lessons. And so that's important. So to be committed on this is one of them. All right, I'll entertain a motion.
I move to accept these rules.
Is there a second?
I'll second.
Excellent. All those in favor say aye.
Aye.
Opposed? Excellent. Motion carries. Thank you, Mr. Burkhalter.
Thank you.
I think Jessica, you're back up on item O.
Yes, thank you. Commissioners, Jessica Hurtado, Enforcement Division. Today, I'm presenting the proposed criminal conviction guidelines for the motorcycle safety program. And these guidelines were developed by a work group of TDLR staff and advisory board members who volunteered their time and expertise to help us develop these guidelines. And I'd like to thank advisory board members Chris Lifton, Robert Rickman, Kyle McNew, and Jeff Alford for giving us their time and effort and contributing their experience to this process. The work group met on December 3rd, and these proposed guidelines were presented to the advisory board on January 7th. The advisory board unanimously voted to recommend them to you for adoption today. And just briefly, I'd like to note for you that these guidelines are divided into two sections, one for motorcycle instructors and one for motorcycle schools. And based on the input of the advisory board members, we split these guidelines into those two groups. And that's because the board members strongly felt that intoxication offenses and offenses against children should be included for motorcycle instructors because of their direct contact and their teaching role that they have with students. However, those same concerns are not present for motorcycle schools who don't have the same contact. If you would like, I can go through each of the proposed categories. Otherwise, we ask that you adopt these proposed criminal conviction guidelines, and I'm happy to answer any questions. Thank you.
Commissioners?
Make a motion to approve.
Is there a
I'll
second?
second. Yes, sir, I'll second.
All right. All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you, Jessica. Appreciate that. We're gonna go to item P. Mary, are you on?
Yes, Chairman, I'm on.
Okay. All right, Mary. I know we're gonna do the appointments. Are you gonna go through this, Mary?
Yes, we will run through it. I believe we have a PowerPoint so everyone can follow along. Thank you, Tamala.
Thank you for your PowerPoint, Mary.
Okay, so we have appointments, a few reappointments, and some presiding officer appointments. And we will start with the first appointment is Mr. James Graves Jr. out of Houston for the Air Conditioning and Refrigeration Contractors Advisory Board. Next, we have Board of Boiler Rules, Mr. John Iannone, and if I'm killing his name, I will get that corrected really quickly. Next, we have for Combative Sports Advisory Board, Mr. Forrest Washington out of Houston, Texas. The Electrical Safety and Licensing Advisory Board, we have Christopher Bass out of Nederland, Texas. Then we have Midwives Advisory Board, Ms. Terry Fruga of Colleyville and Ms. Melissa Bates of Katy. Followed by the Property Tax Consultants Advisory Board with Ms. Andrea Fahrenholt from Conroe, Texas. That ends our appointments. Next, we have reappointments. For the Advisory Board of Athletic Trainers, we have Ms. Brittany Webb from San Marcos, Texas. For the Architectural Barriers Advisory Board, we have Mr. Ron Menard and Ms. Kathy Ann Riley of Jipping Springs and Austin, respectively, for reappointment. For Combative Sports Advisory Board, we have Dr. Wayne Lee from San Antonio and Mr. Blaine Seville Sr. of Austin. For our licensed breeders, we have Mr. Joseph Levine from Burleson for Property Tax Consultants Advisory Council, Stephen R. Dunson of Fort Worth. For Texas Property Tax Professional Advisory Committee, I'm going to say that one more time correctly. Texas Tax Professional Advisory Committee, we have Michael Craig McDougall of Lubbock. And for Towing and Storage Advisory Committee reappointment, board reappointment, we have Mr. James Spears of San Antonio, Texas. For our Used Automotive Parts Recycling Advisory Board, Mr. Brian Burgess of Lubbock. And for Texas Water Well Drillers Advisory Council, we have Johnny L. Mr. Rusty Gilmore from Dalhart, Texas. Finally, we have presiding officer appointments. For Advisory Board of Athletic Trainers, we have Ms. Brittany Webb of San Marcos, Texas. For Dietitians Advisory Board, Ms. Janet Suzanne Hall of Florence, Texas. And for Dyslexia Therapists and Practitioners Advisory Committee, we have Ms. Helen Masick of Dallas, Texas. That does conclude our appointments for consideration by the board. I'm sorry, used to doing advisory boards, by the commission today. Are there any questions?
I'm going to give Mr. Francis a couple minutes. He wanted to address the presiding officers, and then I'll have any comments from the commissioners. Mr. Francis.
Mr. Chairman, thank you. Brian Francis, Executive Director with TDLR. First of all, I want to commend Mary and her team. They do a fantastic of vetting and taking all the applications. There's a whole lot of work behind the scenes. They also coordinate with our enforcement division as well as our RPM division to get their look on applicants before they even come to the commission. And then, of course, the chairman's time that they spend with the staff. I would briefly like to give an incredible thank you to David Weir and to Robin Kauser. Those two were the presiding officers from the very beginning when the programs for athletic trainers and dyslexia therapy were transferred to our agency. Our agency would not have been successful or as successful in transferring those programs without their input. They shouldered a major load. They were able to help bridge the understanding of our agency's culture with that coming from the Department of State Health Services. David, thank you so much. TDLR owes you a debt of gratitude. The athletic training industry owes you a debt of gratitude. Robin, you and I had so many phone calls back and forth on what does this provision look like? What are the rules work? You wanted to know so much so that you could communicate it to the new licensees coming to our agency. Thank you for the grace that you gave us. Thank you for your commitment and your service to Texas. It will not be forgotten, and our agency is better because of what you did leading those different advisory boards. So thank you so much.
Thank you, Mr. Francis. Any other comments from commissioners? Okay, I just want to tell you, commissioners, that there are a lot of changes through legislative action that are going to be occurring. I think everybody was assigned a subcommittee. I'm going to take about 10 minutes for each committee that, and just specifically got impacted. I would ask you to please, if you get a chance, to pop in, hear their comments so the commission can hear directly from these and thank them for what they're doing, because they're doing a great job, and we know they're not doing it for the pay. So, but there's a lot of changes going to be going on, and they're going to have a lot of, I think, input as to what it means, and we want the commission to be front and center. And also, I would implore you to please send me names that you think would be good for these committees. We always are welcoming new faces, fresh faces as this changes. These committees are our eyes and ears on the street. So if you have some names for these committees, please send them to me or Mary, and Mary and I will go through them. Okay. All right. I'll entertain a motion.
Make a motion to approve all appointments.
Second, Commissioner Collier.
All in favor, say aye.
Aye.
Opposed? Good. Motion carries.
Thank you, Mary.
All right.
Thank you, everyone.
Thanks, Mary. Item Q, staff reports. Mr. Francis.
Mr. Chairman, Commission members, I'm Brian Francis, Executive Director with TDLR. Boy, do we have a lot to talk about, but we're going to condense it down for you. I want to spend a good portion of our staff report on legislative updates. It's a fluid, moving process, but where we are in the journey, I think, is extremely exciting. If I could, I'm going to invite Steve Bruno to give us a quick overview, Christina Kaiser to delve into the sunset updates, Also racing, and Christina, I'll join you on the racing conversation. And then Mike Arizmendez to kind of lay out where we are on the important dates that are associated with the legislative process. Then we'll be available for questions. Then we'll slide down to the COVID update from David Gonzalez. Mike will provide a hub report update. David will give a brief overview of some of the delays and changes and improvements, the things that we're doing to try to make things better at the agency. And then we'll be available for any questions after that. And then Mike and I will talk on 2 big personnel changes. So Stephen Bruno, are you with us?
Yes, sir. Good morning.
Okay, we'll have you start, and then you and Christina and Mike and I will bounce in.
Excellent. Good morning, commissioners. Thank you very much. I want to give you an update on several of our strategic initiative bills that are moving along throughout the process. The first one I'd like to talk about is House Bill 4184 and its companion Senate Bill 1480. These are the bills that will help us modernize and streamline and better regulate the offender education programs that we have. As you may recall, those were part of a transfer to us, and there are several different programs scattered through different statutes. And so with this effort, we are bringing those all into one statute and providing modernization based on some of the lessons learned from our COVID-19 experience, which includes allowing certain courses to be offered virtually. This is a bill that is scheduled to be heard on Saturday. Yes, you did hear that correctly. The House will be working this Saturday. And this bill is on the local calendar, which is a place reserved for non-controversial items. And because of some procedural things that have happened, because it's a companion bill, the Senate version, the House bill is on the calendar for Saturday. The Senate version is already over, and it's been heard and sent out of the licensing committee, which means that it's eligible to be swapped out for the House bill basically on Saturday. And that should move as we expect. And then that bill will be headed on its way to the governor's desk after the move on Saturday. Senate Bill 40 is another bill that was a lesson from COVID-19 experience, and it would allow for telehealth across TDLR's health programs. It would give you, the commissioners, the authority in all of those programs to prescribe rules for the use of telehealth. Senate Bill 40 has cleared through the Senate. It was heard this week in its House committee, and we expect that it will be voted out and sent to a calendar very soon. Senate Bill 2062 is going to make permanent the Motor Fuels Advisory Committee. You may recall that when we inherited the Motor Fuel Metering and Quality Program last session, there was a group put in place in the bill that functioned much like an advisory board. However, it was temporary. It was to help with the transition from that program. And so with this effort, that will become a permanent advisory board, looking a lot like our other advisory board made up of industry experts who can provide you all the advice that you need when it comes time to making decisions about any possible rule changes and the advice that the department needs to help regulate that program. House Bill 4086 is one that is related to our elevator program. What this bill does, it's very short, and it's born out of a concern for safety. It was part of our strategic initiative, and it says that for elevators that are going to be installed in private residences, in people's homes, that those will be installed by one of our licensed elevator contractors. And then the other thing it says is that for older equipment, there is some certain older equipment in home elevators that could pose a danger to children. And what this bill says is that if there is not enough space, if the space is too great between the hoistway and the elevator, then an item, which is a relatively simple item called a door restrictor, will be put in place so that the danger that is possibly posed to small children and having possible injuries in those home elevators would be eliminated. That bill has been heard in the House, and it's been recommended for a calendar and will be moving out of the House, we hope very soon, and then it'll be picked up in the Senate. And those are the bills that I wanted to update you on today, and I'm happy to answer any questions about those or anything else regarding the process, as we are definitely in the thick of it right now.
Questions? Extraordinary job, Mr. Bruno. Extraordinary job. Lots of moving parts. Thank you.
Thank you, Mr. Chairman.
All right. Mr. Francis? Christina, go ahead.
Good morning, Mr. Chairman and Commissioners. I'm Christina Kaiser, Deputy Executive Director for Regulatory Services, and I'm happy to update you about a couple of bills. The sunset bill for TDLR, House Bill 1560, had some good progress last week. It was heard in the full House. The committee substitute specifically was heard in the full House on a second reading on April 29th, which was Thursday of last week. One amendment was voted on at that time, and it was voted down. The next day, Friday the 30th, it was heard on the third reading, and an amendment offered by the author, Representative Goldman, was adopted, and then the bill was voted on, and it actually passed the House that day. Its current status is that it was received in the Senate on May the 3rd. I would offer a few highlights about the changes that are reflected in the committee substitute, if that's okay. One change is that in the committee substitute, the auctioneer program is not deregulated. The original version of the bill had that program being deregulated. In the committee sub, there is a recommendation or a provision for a study to be conducted by TDLR in cooperation with the advisory board and the industry to modernize and strengthen the statute. Another change, there were several changes in the committee sub related to the cosmetology and barber consolidation. One is that the method of combining the definitions of cosmetology and barbering was much improved in the committee substitute. In the original draft, there was cosmetology is all of this stuff, and then barbering is all of this stuff, and most of those things that were listed separately were the same things. And so in the committee substitute, they combined those definitions and said cosmetology and barbering means all these things, and then down below, in addition, for a barber, you can do this thing. And in addition, for a cosmetologist, you can do this one or two things. So it's a much cleaner method of combining the two programs. Brian, did you want to jump in?
Yeah, Christina, I think it's important for you to highlight that didn't happen out of the ether. That was because of the work of you and your team going back and saying, how can the bill be improved, and offering those recommendations to the Chairman Goldman, who accepted those as amendments. Y'all did a great job of rewriting that element to make it more streamlined. So I know you're being modest, but I don't pay you to be modest. I pay you to be effective.
Well, thank you. Thank you, boss. Yes, we did make those recommendations, and we were very happy to see those incorporated. Another change related to the cosmetology and barber consolidation is that in the committee sub, instructors are not deregulated. There was a lot of public feedback in the written comments to the Sunset Report, and then there was also public feedback offered in the committee hearing on this bill. And so as a result of that, the author thought better of that. In the committee sub, also the DES, Driver Education and Safety Program, would not be subject to the major overhaul that was recommended by the Sunset Commission. Instead, the DES program would also be subject to a study conducted by TDLR in cooperation with the industry to determine methods of streamlining and modernizing the regulation of this very important program. And one other thing I'll mention about the committee sub is that also a program, the residential service companies, that is currently regulated by the Real Estate Commission, would be transferred to TDLR as part of the committee sub.
Which one is that?
Residential service companies.
Yeah, Commissioner Tallier and commissioners, think about residential service company contracts as just a cousin to service contract providers. It is a subcategory, a subset of service contracts. So if you have it for appliances, you have it for used vehicles or new vehicles, and now you have the same type of product that's for homes that are existing or being sold. When I was at the Real Estate Commission, this was one of the programs that I helped actually put together, and so it just fits right under SCPs. There are approximately 54 of these licensees that are currently over there.
Thanks, Brian, for that clarification. Yeah.
I'm sorry, I spoke over you. Also on the subject of sunset, I would like to mention House Bill 1600 by Representative Canales is the sunset safety net bill. That's a very important bill as well, because if our main sunset bill doesn't pass, this one will keep us in existence for 2 more years. That has passed the House, and it is currently pending in a committee on the Senate side, and that is the Committee on Administration, and we expect that will be voted out soon. There is another sunset bill that is also of interest to TDLR. Senate Bill 704 by Buckingham is the sunset bill for the Racing Commission, and a committee for this bill provides for the transfer of that program to TDLR. That bill, that substitute, was voted out of committee on April 29th. It was heard in the Senate on 2nd reading and then on 3rd reading just yesterday, May the 5th, and it passed the Senate. It was voted out of the Senate. On the House side today, that bill has already been read on 1st reading and referred to the Licensing and Administrative Procedures Committee. So it is moving along quite fast. Brian, was there more that you wanted to mention about that bill? There's a couple of other bills, if you don't mind, I'd like to highlight, but please jump in if you would like.
Commissioners, Brian Francis, Executive Director with TDLR. So first of all, to my leadership team, we've got a total of 5 minutes for all the rest of the items. So very quickly on racing, it's a heavy lift, it's a heavy opportunity. My team continues to be 1st grade students on this, literally sitting on the front row and just learning and learning. If the program comes to it, we're going to honor that industry, and we're going to do it the very best we can with TDLR. We'll continue to bring you up to speed on that. Christina, you can highlight those other bills. Mike, I would like for you to do the hub report. And David, if you can just touch just briefly on the vaccine process that we undertook. And I think that's fine. So Christina, you got a minute to finish the rest of what you're going to finish. And then Mike, and then David.
I would mention that House Bill 3616, which removes the automatic bar to licensing for people with a prostitution conviction in massage, has passed the House and has been referred to a committee on the Senate side. This would be a great win. House Bill 4214 was heard in a House committee yesterday, the Committee on Corrections, and left pending. 4214 is consistent with the discussion earlier about second chances. This would allow TDLR by rule to accept applications or possibly even issue licenses to people while they are still incarcerated, as part of a, closing that gap that people often experience when they first get out of prison, to help people get employed more quickly and not be sort of left floating out there. That concludes my report. I'm happy to answer any questions about any of those items.
Yeah, that's definitely good news. Thanks, Christina, for sharing that. Loving the House Bill 4214. I mean, right direction, as I indicated earlier. Truly a win. The House Bill 3616 as well. That will mean a lot to to individuals who have those type of circumstances. The instructors that for not being deregulated, I can definitely say that I had a few phone calls that came my way from folks who were extremely scared, extremely. So that's a positive, and please keep me alert for that. Thank you so much. And this 30 seconds does not count against Mike.
No, it just counts against you, Commissioner. No big deal. All right, Commissioner. Brian, you got Mr. Mendez right now. Is that right?
I've got Mike and then David, and then I'm going to do 22-second commercial.
Mr. Chairman, Commissioners, Mike Harris-Menace, Deputy Executive Director. I would add a couple of things on that note before I move to my other ones. Next week is a big week for us as far as the legislature is concerned. There's some key dates that begin to start happening Monday, but essentially Thursday and Friday. Thursday is the last day to hear or have second reading on House bills. And then Friday's the last day to have third reading on House bills. So things will start moving pretty rapidly after that. And so we'll see. As far as the hub report, I would let you know that to date, we have attended 5 events, and we currently have 5 events scheduled. One of those that we've attended and actually hosted, and another one that we will host, will be the TDLR Speed Network meeting for hubs. And so our next one coming up will actually be next week on May the 12th, which will be next Wednesday. So currently, we are at about 31.23% of our budget spent on hub, which includes commodities, other services. The statewide average is 11.74. So you see that we are about 3 times what the state spends on hub vendors. We are at 31.23%. So I'll let you know that we continue to promote our mentor protege program. We have not had any additional since the last meeting that we discussed, but Brandy and her crew continues to actively pursue that and chase everything they can on that mentor protege program. So, and with that, I can cease and let David take over, and I'll be happy to answer the questions.
Yeah, if I may, this is Commissioner Collier. So, Mike, how many mentor protege relationships are in place now?
Currently, to date, I can tell you that we have. I just had that information. Bear with me. We currently have 3 mentor protege programs. We have Taurus Technology, to be a mentor to Tegration LLC. DKG Group is a mentor to Global Insurance, and they also want to be a protege also for another bigger program. And then Crestway Group is participating also in the mentor protege program.
Okay, yeah, that's huge, Brian. You know, as you meet with your colleagues, right. Thank you, Mike. I appreciate the update and report. I know on some of the bill side, do any of the hub bills have any wings? Specifically, I guess the Senate bill that Boris Miles had presented to Boris Miles.
I can tell you that was discussing this yesterday with Brian and Steve Bruno, and there will be changes made to it if it's introduced. At this point in time, we're getting late in the game that those type of bills are going to have a difficult time getting traction, I believe. And Brian can probably verify that even more so, or Steve Bruno. But the one that we were discussing, we know that we'll have a substitute, which according to the bill author would improve the program and not disseminate it, but we're not sure exactly where that stands. We have not seen anything on it.
And
thank you,
Commissioner Cal, this is Brian Francis. This is to you and all the other commissioners as well. If you need any more detail on our bill tracking, Steve Bruno will be available, and he also works late on weekends. So he can do one-on-one conversations on bills that we are tracking or any other bills of interest to you. He's got those connections. So we want to definitely offer that and give you the time you need to have those conversations.
All right, Mike, anything else?
That's all I have. SB1 continues to move on, and so it's currently in conference, and so we should be hearing the results of the conference committee report on the budget. So the comptroller just recently released his another revised estimate, increasing the budget appropriate revenue to 1.7 billion additional, which now means that he's projecting that we will now be in the black, 750 million, which is a big step for the state of Texas. And
big deal.
I will rest. I will. Thank you, sir.
It's a big deal.
All right. Good morning, Chairman, Commissioners. David Gonzalez, Deputy Executive Director of Licensing Services. I'm going to give you one update regarding the COVID-19 response. We actually cannot require staff to obtain vaccinations, but we have strongly encouraged it for all of them and went as far as coordinating with the local pharmacy to offer shots at our North Campus, where we had approximately 75 staff or their relations obtain their first COVID vaccine. So big round of applause for our human resources staff. Sharon Hamoya and her staff did a phenomenal job coordinating that. So very proud of them for that participation, and kudos to them. We also want to acknowledge the idea came from our participation in that interagency group Brian referred to, that we've chosen to communicate with and navigate and share ideas as we navigate through the pandemic. So that's all I have to share today, and I'll turn it back over to y'all.
Mr. Gonzalez. Mr. Francis.
Chairman, I'll close out with this. First of all, Brian Francis, Executive Director with TDLR. Commissioners, if you have not noticed, these three deputies they're Atlas for me. They are carrying huge responsibilities. If you drill down to it, Mike is carrying the responsibility of navigating our budget through, getting the funding that we need as an agency. Christina Kaiser is carrying the responsibility of Sunset, setting our agency's model and our infrastructure for the next 12 years, all the way to 2033. And David Gonzalez is chairing, and he's the champion for our Texas licensing system. Those are three of the biggest things that we've got going. Yes, there are small spots there, but these three are carrying those. It's not Brian carrying it, it's them and their teams carrying it. And I'm telling you right now, I am in great hands, and our agency is in exceptional hands. They are owning it, and they are driving it, and they are creating it. And I'm just so proud to be associated with them, and they are outrunning me. It's not too hard to do for a big guy like me, but no, they really are outrunning me. And that's such a pleasure as a leader to know that you got folks like this that are carrying the baton and accelerating down the track. Mr. Chairman, that's all I have.
Excellent. All right. Well, I think we've got a great year right here, and I commend you guys on that. A lot of legislative changes. If you don't like one, just wait 5 minutes. It's all going to change. That's all I got to say, because it will change, and it's done that several times. So, all right, we're going to go on. First of all, our next commissioners meeting. I think Tam is working on that right now. Tam, is that accurate?
Yes, sir. July 6th is the front runner, but I haven't heard from everyone, so I'll let you guys know at the next in a couple of weeks.
Perfect. Commissioners, make sure you respond to Tam. We want to make sure we're going to be evaluating each meeting accordingly to health safety standards, but also to be present. We know the state legislature's back in full force, but we want to make sure and be aware of everybody's needs. Brian and I were able to do a video and talk about Mutt and Jeff show. That was pretty much, it was Laurel and Hardy thing, but we did a video about just emphasizing that we're always going to respect people's individual opinions, and our culture is who we are. We're not a bureaucratic body. We're a culture of people who strive for excellence, and we will stay that way, virtually or in person, or both. And we will never continue that. I also want to wish Della, thank you. Charles, are you still on there? Both of you guys, you babysitted us well. I'm just gonna tell you, you did a great job, and you held our hand well. Thank you so much, Della, for that. And Charles, I don't know if you're on there, but thank you so much for that. You two guys did a great job. And Commissioner's extraordinary conversation on many of these cases. I cannot say with that much emphasis that Texas is proud because of our dialogue that occurs. The diversity of opinions, the ability to go through things, it is rare air, and I appreciate and respect that. Also wanted to wish everybody a happy Mother's Day. So if you hadn't got your mother something, shame on you. Go get your little butt out there and go do it, and get some flowers. And so take care of Mama. And with that, I will entertain a motion to adjourn.
Mr. Chairman, could I say one thing?
Could I possibly stop you, Mr. Francis?
David Gonzalez, happy birthday.
Happy birthday, David Gonzalez. I could not. All right. Oh, man.
54 today, and I started at the agency 25 years ago on this date.
54 today, 25-year anniversary. I think there's dirt younger than you, Mr. Gonzalez. Good Lord, 54. Good night. All right. Well, we cannot say thank you. Happy birthday, Mr. Gonzalez. And again, thank you all for all you're doing. And anything else, Mr. Francis? We'll get the motion.
Make a motion to adjourn.
All right, all in favor, say aye.
Aye.
Opposed?
Thanks.
Thank you.
Thank you.
Thanks,
Commissioner,
everybody.
Staff, thank you all so much. Great meeting.